May I please, Your Lordship. Lordship, I'd like to mention in item number 31, I on behalf of respondent number 2, I had filed affidavit and Ogalana, so kindly call for the same.
May I please, Your Lordship?
31.
May I please, Your Lordship? Lordship, I beg to pray for adjournment item number 44. My senior is, Sri O.P. Bhatti is presently out of session. Lordship,
Kindly inform the other side. You are for the petition.
I have taken the consent. Lordship, can that matter be fixed on the first week of November?
It can be. Fix an adjournment for the day. List in the first week of November on 7/11.
Obliged.
May I please, Your Lordship? Lordship, yesterday, Lordship, I have filed one additional affidavit, Lordship, in
Mhm.
connection with item number 9, Lordship.
Bring it from
Lordship, kindly that may be called for.
Okay.
Deeply, Your Lordship.
Item number.
May I please, Your Lordship, I beg to mention item 20. CD is received, but the engaged counsel is having some personal difficulties, so kindly retain the CD and may be listed on Friday.
CD has been received.
Yes, CD.
Okay.
Okay, obliged, Your Lordship.
And adjourn for the day, fixed on 7, CDB retained, case diary moment retained, fixed on 17/10. Okay. Friday is 17.
Yes, obliged, Your Lordship.
My lord, I beg to mention item number 42.
My lord, I have objection on this. They are adjourned this.
My lord, my senior colleague, Mr. Josati, is unwell, my lord.
My lord, in this case, your lordship will notice items number 41, 42 and 43 are tag matters, my lord. And every time on the last 3 occasions,
Not
my
every
lord,
time, my lord,
my lord will-
only one time, my lord.
my lord will see the records. They
My lord,
every time,
He's
let me
unwell, my
submit.
lord.
Let me submit. Every time they come and seek adjournment, and my case also gets adjournment. If they don't want to argue their case, it's up to them. But my case should not be
Yours is
adjourned.
separate.
These are tag matters, 41, 42 and 43. And my lord, this is a case, if your lordship is come up for hearing, most likely this will go for remand back, my lord. But because they have been seeking adjournment for almost 9 months, my lord, this case has got adjourned.
Anyway, okay, I take note of your prayer, I accommodate you, but we can just explore it when it
My lord,
comes,
my lord.
if it reaches.
Let the matter reach, my lord.
When the matter reaches, we'll explore it and what can be done, if it can be segregated to some extent. Okay.
Deeply obliged.
May I please, Your Lordship? I beg to mention item number 11. I'm for Department of Customs, and this matter, I need some,
Time?
item 11,
No, you need some time for,
some time for filing our objection, and I need some instruction from the department, madam.
but he must be in custody. Okay, you
Yes.
take your current counsel appearing for the customs department. Seek some time, file an objection, and also take some departmental instructions. Prayer is allowed, but he must be in custody for a long time, maybe. I don't know actually,
Yes,
because it is likely to be commercial quantity. Scan TCR has been received.
yes, sir, yes, sir.
No? Received. So when do you want it? After
Can you,
how
my
long?
lord, I'm for
No
the
problem.
petition, I'm for the petitioner, my lord.
You're for the petition.
Yes, my lord. Can it be next week, my lord, any date, my lord?
Is it okay for you? Next week.
28 may be fixed.
Hmm?
One on 28 or 29th,
2/8,
2, madam.
My lord,
28/10.
my lord.
Highly obliged.
May it please your lordship?
Mhm.
Lordship, I beg to mention item number 5, your lordship.
Right.
Matter may be adjourned for the day as my senior is out of session, your lordship.
No problem.
My lord,
Counsel.
I'm for the sole respondent, my lord.
Okay.
I strongly objection on this petition, my lord. Since 2008, my lord, the sole respondent is suffering, my lord. One after another, taking the plea.
Earlier
and
also.
resisting. Already in this criminal petition also, my lord, after taking the interim order, my lord, they are taking the time only. Already 4 days taking the time, my lord.
Anyway.
So, my lord, my humble prayer, my lord, kindly vacate the interim order, my lord. The
No,
interim
that
order
I
dated
can- I cannot take a decision on that without going into the file. So let's what we'll do.
Matter may be fixed on Thursday, your lordship.
Thursday. Otherwise, don't worry. I mean, we can just take up the matter at the appropriate time and see it. Or in any case, it will be after the bail. So one option is to take it up when it comes up and just look into it, and hear what he's saying and. But okay, you're seeking some accommodation or to fix it on another day this week, as you
Matter may be
as you
fixed
suggest.
tomorrow or Thursday, your lordship.
You'll be available.
Yes, your lordship.
Okay, let them fix it. Otherwise, I could have seen a little bit of it actually, what you're saying. Lord Council, your good name, please.
Adas, your lordship.
It does Lord Council, 6 an adjournment, of the matter. As the leading council stated to be outstation, full stop. B Islam Learned Council for the petitioner, right? Sorry, she's for the petitioner, however. And Learned Council for the respondent number 2 objects to the adjournment, submitting that there is an order of stay. Learned Council, Ms. Das, prays for fixing it on Thursday. List the matter on 16/10, okay? 16/10, we'll see it. We'll see it, 16/10. On that day, we'll go into it and see what can be done.
Yeah, please, your lordship. I beg to mention item number 29, lordship. In this case, earlier occasion, CD was called for, perhaps CD is not available today.
Item number?
29, lordship.
You're on interim.
ABT.
Your interim is there.
No.
No interim.
CD not received.
CD not received. So fix another date.
Another.
Case diary 29. Fix the case diary. Issue reminder for the case diary. This is the matter on
On my lord, 24/10.
next Tuesday, 2014.
May I please, your lordship? Not, I was to mention for listing 3 bail application, my
New
lord.
applications? New applications?
Lordship,
Then
lordship.
you have to mention before the senior bench.
My lord, earlier rejected by this court.
For this, then you have to, then you can file it. You have to file it here.
Lordship.
No issue.
May I
On-
please-
on-
Today only, or you want it this week?
Well,
you want
on
to move
16,
it-
on 16 or 15.
16, take it on
Alright.
16.
May I please, your lordship? Lordship, I beg to mention for a listing of criminal petition, lordship. It's a long pending, your lordship.
Criminal petition, I think.
Under a special act, your lordship.
Special, can I take it? To Senior bench, someone. Just guiding me about the so standard practice direction. If I can take it, no issues. Bail matters, no, it's a criminal petition, it says. Criminal petition. Criminal petition. Which one, bench, কোনখন? Criminal petition. Bail pertaining to special acts, it's my, roster. But general criminal petition, I'm not sure actually. You can just, it'll be the same thing. It will come to one of the courts. You can try Justice Kolita, on AM Kolita.
Okay.
You can mention at 2 o'clock if necessary.
Obliged.
May it please, your lordship. Lordship, item 48, my lord. I am praying to take up this matter at 2, my lord. Because in this criminal petition, my lord, pertains to child marriage, my lord, no stage there.
In any case, it will be in the second half only, most probably. By the time it reaches, it will be second half only.
I'm,
Take it up, second half.
Pronouncement of judgment, item number 45, criminal division petition 369 of 2024.
This was allowed.
Well,
Actually, this was ready quite long
No,
time
my
back,
lord.
actually.
My-
By
my lord-
mistake, it did not get
my
listed.
lord had dictated almost.
Yes, yes. So, just before the vacation,
My lord
it
has-
was ready then only, but it did not get listed, so it became CA.
My lord has given a date, I suppose,
Hmm.
for appearance.
10/11.
10/11.
That's okay, 10/11.
Obliged.
Number 1.
My lord, FIR is at page 16, my lord. The petitioner is apprehending arrest in connection with this case, in connection with this case whereby this vehicle was intercepted by this police on 20th of April and two persons were arrested. Those were driver and handyman with some unloaded articles. Those were without any proper documents found in the said truck. So my lord, actually what happened, the petitioner was the owner of this vehicle once upon a time, and his vehicle was sold to one Sanjay Kumar by virtue of an agreement which was executed between them on 25 June 21, which your lordship will find at page 13, my lord.
The driver and the handyman were apprehended.
Apprehended. But this vehicle was sold in the year 21, and this transfer of the vehicle was done to in favor of some other persons or no, that was not within the knowledge of this petitioner. Because he has sold this vehicle by virtue of agreement to one Sanjay Kumar. And what is done by Sanjay Kumar subsequently, that is beyond the knowledge of the present petitioner. So my lord, I may be.
Then in the registration of in the
registration-
transport records, it is still in his name.
Still in my name.
So that should be transferred. then.
So that's why.
Otherwise, my lord, they cannot transfer the vehicle. Vehicle is already hypothecated. So.
No, that's also hypothetical vehicle
Ah.
belongs to the finance company actually anyway. Irregular transaction. Okay, you appear and record your statement. 482 bill application, Umrangsu PS case number 9 of 2025, under section so and so PNS. The cases arose out of FIR dated this sorry 25 with the lodged by Lance Naik, LANC, with the allegation that he along with staff while doing night patrolling duty at the stated place of occurrence, found a truck bearing registration number BR 06 GD 7851 coming from Meghalaya. And during checking, the truck driver Nuru Hussain and handyman Jitu Deka stated that it was loaded with cement and showed some documents, but upon checking, it was found to be loaded with coal. So, the present petitioner is stated to be the owner. The present petitioner is stated to be the owner of the said truck, who supposedly in the meantime had already sold his vehicle
20
by an agreement. Which is annexed as Annexer 2 to one Sanjay Kumar. Full stop. In this regard, the learned additional PP points out that being a hypotheticated vehicle, first transfer cannot be done. In any case, call for the case diary. Full stop. However, in the interim, in the event of arrest, he may be allowed to go on bail, 20,000 once. Appear before, cooperate with investigation and appear before the IO, making himself available for examination. Shall not hamper or tamper with evidence.
On 411.
411.
Within 411. No.
Next date is 411.
411.
No, I'm not giving any time. You appear.
Obvious.
411. List on 411.
Wait, please. There's an application seeking quashing of an FIR, my lord.
Tell me.
FIR is at page 28, long FIR, my lord. Page 28 from 45, my lord. Filed by owner of a car dealer, my lord, citing some money misappropriation, my lord. In the year 2020, my lord, he has filed this FIR, my lord.
Charge sheet has been submitted.
Charge sheet has been submitted, my lord.
So, you want quashing of that charge sheet.
Yes, my lord.
Cognizance has been taken.
Yes, my lord, take it, but your lordship, can you look at the charge sheet at page, my lord, 59, my lord? Without any investigation, my lord, this has been filed, my lord.
Just a minute,
I'm one Rajkumar Gupta, my lord.
just a minute, let me have a look.
We have been arrayed since, my lord, we are in the office at that point of time, my lord. Main accused has been already let off, my lord. The general manager, my lord. Now, after 4 years, my lord, this has been filed, my lord. And in the FIR also, my lord, there is nothing specific against this petitioner, my lord. All the allegations are against the general manager, my lord.
That has to be seen.
My lord.
So,
At this stage, my lord,
what is the exact stage of the case?
my lord, I have received summons, my lord, summon, my lord.
Yeah,
on the- Yes, my
Are
lord.
you in a position to say?
Yes, my
You have received summons. That is,
Summons, my lord.
okay.
The next date is on 17. So, my lord,
1711,
1710, my lord.
1710.
Yes, my lord. So, may I pray, my lord, at this date?
17, this.
Yes,
week.
my lord. The notice may go, my
Look,
lord, until at least
Uh,
next.
We have to get the CD and.
Yes, well, CD and the LCI, search sheet, man.
Scan CD.
Scan
and
copy of the CD
Search.
and search sheet.
That we have to see. Otherwise, at this stage, you
Yes.
My lord.
have to go inside.
Yes,
right?
my lord.
So let it, next date, let it be in the admission column.
Yes.
And on the question of stay, well, date is, you have been asked to appear.
Yes, my lord. On 17, my lord. Unnecessary, my lord, I have
These
to
are-
engage the
they-
council, my lord.
The magistrate will be able to give bail to you. Anyway, that's it. It's okay.
Already protects bail assist.
They are on bail already, must be.
Yes.
Right. So I'll stay for the next, take the next date of list.
My lord.
Yes.
Current counsel for the petitions. Stop. Instant criminal petition invoking jurisdiction on the 528 BNSS. 6 quashing of FIR dated 28/12/2020 and charge sheet dated 25/9/2024. In pertaining to Lakhimpur PS case number 1277 of 20 within bracket GR number 2899 of 20 dash that pending before the court of learned JMFC, not Lakhimpur. The case is stated to be at the stage of appearance as the accused persons petitioners have been summoned and next date fixed on 17th October. Full stop. Heard learned additional PP. Call for the scan copy of the case diary and the charge sheet of Lakhimpur PS case number 1277 of 20. List the matter on the next date in the admission column. Considering the fact that the next date is fixed this week itself, therefore, till the returnable date, till the next date of listing before this court, the further proceedings in GR so and so shall remain still. Sometimes there is this lot of delay in charge sheet, but that itself will not make it better.
Only,
But we have to see why, whether the filing of the charge sheet is justified.
only so far as related to the present petitioner.
Hmm.
Only in so far as.
My lord. Against the FIR also, there is nothing against me, my lord.
So that we have to see.
Yes, my lord.
Okay. So, another thing, issues, steps of notice may be taken upon respond number 2.
Do, my lord.
Only in respect of the present petitioner, man.
Yes. Yes.
Yes.
Others can, the rest of the case can proceed?
Yes,
yes.
Otherwise it will be
Yes, yes,
prejudiced.
yes, my lord.
Further proceedings in GR case with regard to the present petition. Bold wording. Sorry, thank you for pointing out. So list on,
On my lord,
within a month you can fix it.
yes.
After a month maybe.
Yes, on 11/11, man.
11,
7/11.
11.
Yes.
11.
Admission column.
My lord. Much
Then
obliged.
then we can see
My lord.
and look into it. 11.
There is delay, I cannot say.
May I please, your lordship, the matter may be passed over for the timing as Mr. Kelly is on legs.
Is on another?
Yes, your lordship.
Just a minute. This scan copy must, this is. Yeah, it has been received. No, okay.
For the timing one.
After some time.
Yes, your lordship.
You argue to get, that will be better.
Item number 7.
As per office note, my lord, TCR has not yet been received.
PCR has not been received. Stop it. Kamrup Metro. Learned Council points out that as per office note dated 19/9/25, as per office note dated 8/10/2025, scanned TCR is still awaited. We'll wait for some time.
Yes, Lord, I'm on behalf of the informant, Lordship.
Or-
I'm also,
Since 331 days.
may I submit, Lordship?
POXO matter.
Yes, Lordship, and I have an objection. Already he was enlarged on bail, suppressing that this case is pending. I am filing that IA, Lordship, that this case is pending, only TCR has not yet been received. He has filed this, this case was filed on, Lordship. Hmm.
He was released in another case.
Sorry.
He was released on bail in another case.
No, same FIR, Lordship, exact date I'm telling, when that case was filed. This present case was filed on 17/6 and registered on 19/6. Then the next bail application was filed on 22/7 and registered on 28/7. And in that bail application, Lordship, he was enlarged on bail. This honorable court was pleased to, and I'm filing an IA in the disposed of petition because that case is not maintainable. Since one bail application is pending before this honorable
This
court.
one, this one.
This one, and how come subsequent bail application he had filed? So I'm filing that IA in that and asking to, praying for registering a case against him. It's liable for perjury, Lordship.
And the thing is that since the court, this court granted him bail, then since the coordinate bench granted him bail,
Yes,
then
Lordship.
why is he not released? Then
He is
should have been-
released, he is released.
He is released.
He is already released. So let this case be kept pending because I'm filing an IA today.
Become
only.
infractions section.
Yes, Lordship, but this case.
Apart from the other
Yes,
aspects.
Yes, other aspects is there.
So-
So,
You want to say something? You want to submit?
I have not understood. My
Yes.
bail petition, bail application number 2029, Abdul Ali.
Uh-huh.
and in that case.
Kindly, are you sure it's the same?
Yes,
person?
Lordship, I can show Lordship.
Madam is saying, as you understood, no, that
That's-
the same person has filed another bail application.
and-
Was released
My
on
lord,
bail.
my humble submission, my lord. When I filed this bail application, CD was called for, scan copy was called for. Earlier occasion, no scan copy was received.
Because that is.
I think, my
subsequent.
lord, that is another one. I am the standing, I am the counsel in trial court also, my lord.
Two sets of lawyers, Lordship.
No, my lord.
That bail
That-
application is being filed
My
by.
learned friend.
Disposed of. Is disposed of.
Kiska by?
No? It hasn't.
And in fact, in the record also, I saw that is there. Same bail application, same, and the informant had not received the notice, Lordship, in that bail application. So I will file the IA and let both the matters be tagged along. And if I'm submitting a wrong submission, then action can be taken.
It's not my knowledge, my lord.
Yeah, this is the reason my submission is that it's a different set of lawyer, Lordship. And I'm appearing on behalf of
Lawyers
the
can proceed
victim
on
and
the basis of
in the
what's
for support
instructed to
person.
them. Lawyers proceed on the basis. of
Yes,
what is
exactly,
instructed to them.
exactly.
That is why the
Lordship.
affidavit is made by the person.
Yes, Lordship, this is the reason.
Anyway, So we'll, you suggest that it should be tagged to
Yes, Lordship. I'll file IA today itself.
learned counsel for the informant, respond number 2, submits that another bail application has been filed on behalf of the present accused in the same case, which has been disposed of by a coordinate bench. And in this regard, he is proposing to file an interlocutory application and also submits that on the next date, this bail petition may be tagged with the aforesaid disposed of bail application.
And in fact, in the record, I saw that that case pending also is there in the record. In the record, while I was checking the office note.
Should we keep it?
Yes, Lordship, that can be.
This is the matter on, when should we fix it? After
On 3rd of November,
Proceed.
Lordship, because since this next
prosecutor? Third, third of
November, Lordship.
November.
Already he is enlarged on bail. My learned friend is not aware because that is a different set of lawyer.
Kindly tell him that why didn't you tell him? Kindly tell that party litigant that you file a bail application. You tell him that this is illegal, you will be responsible. You tell him. Ask him, first you ask him whether you filed or not. First, bring it from his mouth.
And she has not received the notice in the second bail application. Otherwise, it would have been brought before this honorable court.
311.
Deeply.
311 along with
The disposed of matter, I have given that.
PA number
That is BA number 2401, Lordship,
2401 of 25,
25.
within bracket since disposed of.
Disposed of on 25/9/2025.
लिख दिया.
Deeply obliged, Lordship.
My lord, in this case, the petitioner was arrested in connection with the FIR which was lodged by the informant on 12th of January. And he was arrested on 30th of January. So since last 8.5 months, he is behind bar. And one aspect of the matter is that other co-accused persons have been granted bail by the learned subordinate court in this case. This so my lord, and moreover, charges has not been framed in this case till date, since filing of the charge sheet, which was filed on.
Just a minute. Just have a look at the FIR. The present,
14.
he is, he's not a named FIR.
Not named in that.
Not named in that. Just a minute.
He was arrested merely on the basis of
Some more-
suspicion.
Samar Boro Deep Nursery.
My name is Ramleshwar Boro.
Just a minute. I'll have a look. The narration in the chart. And then I'll come to you. Okay, you complete your submission.
Thereafter, my lord, he is behind bar, no charges have been framed, though charges sheet was filed on 31st of March, my lord. Since last 7 months. So, my lord,
May I please, your lordship, in the morning, lordship, affidavit was called for lordship, probably,
It's come.
lordship. No, lordship.
Not yet,
No,
no?
not yet.
After some time?
After some time, no. Scan को तो ऐसे लिख दिया होगा. Scan को तो ऐसे लिखा. कॉल को इसलिए कर.
please, lordship.
Yes, okay, as per office load, dated 24/9/25, service deposit awaited, Lordship.
No, Lordship, thereafter there is an order also, order dated 26/9/2025.
Let me see. Last order, this says that she has appeared for deposition.
Yes,
Then she has appeared for deposition. So
I have annexed
through
the,
local police station services to be effective.
otherwise, Lordship, she has been partly cross-examined, and thereafter, Lordship, further investigation has been directed.
Acha.
And now further proceeding of the case is, away.
Kept in abeyance.
Yes,
She's the informant, right? Are you?
yes.
Victim examined
Yes, informant is examined, medical officer is examined,
and victim.
and
also.
victim is also examined in chief and partly cross-examined.
Okay.
And there is, Lordship, refusal to consent for medical examination.
Anyway, so, but we have to complete the procedure because there is also direction. Prosecution will
Yes.
take steps through local police station.
Yes.
Can we quickly take the instruction since he has deposed in court, can we quickly serve?
And there is order for further investigation also, Lordship. That is also
So
another.
in any case, it is an abeyance now. The case is an
Yes.
abeyance. But he is in custody since?
Since 14/5.
Okay.
14/5 2025.
The learned counsel has drawn my attention to the last order dated 26/9/2025. Scan TCR must have been received.
Received.
So scan TCR has been received, but service is awaited upon respond number 2/informant and was directed on the last day to be effected through the local police station. Full stop. No update on the same is received today. Stop. It is submitted by the petitioner counsel that also it is also reflected in the order based on submission that the respond number 2 had appeared before the court and our deposition recorded. Just for
I have
convenience-
annexed a copy also, Lordship, deposition.
No problem. The prosecution shall take steps for service of notice upon the respond number 2 through the local police station. And also obtain necessary instructions regarding the same. Is it okay? When?
What date were given, Lordship, already? It is the second.
17, if you can manage,
22nd, Lordship.
22nd,
20.
reopening.
Reopen.
List on 22/10.
Obliged.
Wait, please, your lordship. Lordship, this is a regular bail application, lordship, 94 days in jail. Though lordship, commercial quantity, but the recovery not from this petitioner, lordship. These two petitioner was arrested, lordship, for only on the statement of the co-accused from whom that recovery was made, lordship. Lordship, we got that Panchanama that is on page 14, lordship.
Just a minute.
May I please? Your
Yes,
Lordship?
sir,
Your Lordship, we have not received the case diary in this matter, Your Lordship. The department will be able to produce the case diary after Diwali vacations, Your Lordship. So this matter may be fixed next week.
Lordship, twice they have, it is from Guwahati, lordship, they have taken time, lordship.
Then, our, this court, our.
Guwahati zone, Guwahati
Metro
zone.
court,
Yes, Your Lordship, the IO was not available at that moment.
That cannot be the ground, lordship, because it is the petitioner in detention without any fault, lordship. No recovery, specific allegation, lordship. May I take you, lordship, the page 15? First paragraph, lordship, bottom line there. This is specifically mentioned, lordship.
But case diary will be necessary. It's a commercial,
Yes, yeah.
commercial quantity. Can you,
Commercial
can you get it on Friday? Thursday? Is it possible? I mean.
Or
may not be able-
23rd or 24th.
Oh, you said Diwali vacation, no? After
Yes,
Diwali vacation.
24th, can it be, lordship?
Okay, 24?
Yes, Your Lordship.
Third, beach or the standing, the land council appearing for the NCB, right? Is that-
Yes, Your Lordship.
Submits that. The case diary has not yet been received and seeks a date next week for producing the case diary. This is the matter, this is the matter on 24/10.
Other lordship on the failure of that, lordship will consider the bail lordship prior on the basis of the record lordship have furnished along with this.
Case diary will be absolutely essential, 37, determined, because that is the written after perusing the materials. The
But
charge sheet
lordship,
and FR has-
37 lordship, that is applicable if it is recovered from the person lordship. It is not lordship only mayor's
No,
statement of the
that too,
vehicles.
but to determine that aspect
Yes.
also, the official,
Even commercial quantity.
official
recovered from-
documents have to be seen.
Yes,
The rigor of 37 is very high actually, more than,
but that is
UAP Act. But you
not
can-
absolutely bar lordship to release on bail lordship.
Absolutely bar.
Highly obliged.
No, absolutely bar. Cannot be.
My lord, item number 13, case diary received, my lord.
Mhm.
Earlier in this case, my lord, injury report was called for, my lord. There are lots of allegations
Price man.
against the accused. So today, my lord, I contacted the IO, my lord. IO is on leave. My lord, your lordship, my prayer before your lordship, my lord. If your lordship may fix
Oh.
it tomorrow, my lord, if any, my lord, I will not receive the injury report, then your lordship may pass appropriate order.
But injury report was actually rightly called because it is necessary,
yes,
because the
yes.
allegation of severe
Guwahati.
severe injuries.
Yes, sir. There are
And,
lots of allegations, my lord.
Multiple assault, severe injuries. Suppose
Yes.
the injury report does not reveal or reveals a simple blunt injury, then it will indicate that this is exaggerate.
Then also,
That
my
is
lord,
necessary for him also.
for him also.
Mm.
Otherwise, my lord, from the 164 statement,
Mm.
and that there are otherwise materials. because
Otherwise,
there are
length
no-
of delay, my lord, 45 days behind the bar.
Anyway, so that would be fair. Tomorrow or day after.
Day after tomorrow, if I will not receive the injury
Yeah.
report, then your lordship may pass appropriate
Because,
order.
no, actually, I also I
Tomorrow,
can
your
dispose of, but
Yes.
it will be an incomplete adjudication.
Yes.
Tomorrow, my lord, day after.
Because
Believe-
IO is on leave, my lord. I contacted him, then he,
Believe me, that will be not very satisfying for the court also. It can be
Yes.
disposed of, but it will be a
day after tomorrow,
without
My lord, day after tomorrow, I have difficulty, my lord.
tomorrow
Tomorrow.
or Thursday.
Thursday.
If Thursday,
Thursday is day after tomorrow, my lord. Today is,
tomorrow is Wednesday. Right?
tomorrow, your lordship.
I'm still in the past.
Tomorrow, my lord.
The injury report is not yet received, and learned public prosecutor submits that. The matter may be fixed tomorrow. The CD be retained. CD has been received.
Yes, CD received.
CD be retained. List the matter. What, 15, right?
Yes, ma'am.
Deeply obliged.
May 14, my lord, case diary not received.
May I please, your lordship?
Service part is complete.
Lordship, lordship, may peruse the last order, lordship.
Okay. Let me just have a look. Oh, prosecution was to take instruction.
Lordship.
At 2, my lord, I will try to get the instruction. If notice already served, then
Lordship, deeply obliged.
15.
Bed.
15, my lord, already in this case, search sheet submitted, my lord.
Since it is 22C,
Yes.
we have to, charge sheet is submitted, but it was called for. Scan copy, we have
No,
to
ma'am.
peruse,
No,
we have to
scan
peruse
copy.
the materials.
Yes.
We have to peruse the materials.
Mm.
You have received the charge sheet or intimation?
Intimation regarding filing of.
Let us call for the case diary and charge.
Ma'am.
He is in custody since 5/5.
25, today is 150 days, 150 days.
Call for the scan copy of the case diary and charge sheet of Matia PS case number 35 of 25 under section 22C of NDPS Act. So the accused is stated to be in custody since 5/5/2025. List the matter. Don't give a very long date,
Yes, my
a
lord.
reasonable date since
On
Has to be
27/11.
27.
No,
Okay, sir.
Of this month.
27/10.
27, 27/11, my lord.
27/11.
11,
27, no, 27/11 will be too late.
18/11, my lord.
Today is 14, right?
Today's what is in this month, Millard, it may be Millard on September. This month, Millard, any date last,
End of this month.
this is October.
Is the 31/10.
31/10.
Only one thing, Millard, only Lordship mentioned that case number, Matia PS case number 35.
Mhm.
Okay. No, I-
35 days.
Yes.
It's always better to check this.
No, I mentioned it about,
You have written 35.
35,
Should I cross check it once?
name foreign report has seen same Miller.
30.
On my,
68.
May I please, your lordship?
Yeah.
LCR may be called for. Today LCR is not available in this matter.
It's not available? Okay, LCR. And deportations. This is also commercial quantity itself.
Yes, your
no?
lordship.
Here's the last order dated 22/9/2025. It appears that the scanned copies of case diary, charge sheet and depositions have not yet been received. Issue reminder. The accused is in custody since 2/6/22.
Yes, your lordship.
22.
Yes, lordship.
Anyway. So this also, when should we fix it? Within this month, we should fix it.
Yes, your lordship. On 25th.
25th,
Yes, your lordship.
25/10. 25/10.
Much less.
Seventeen also, my lord, POSCO is there, my lord, service report, my lord. Service report, no.
Time. Save
For some time.
save your time, because he wants some time to go through the case diary.
It's the fourth day, your lordship.
Huh?
Fourth day, your lordship, it was. the
No, no,
state-
today only will take.
Lordship,
Today
lordship,
only will take.
lordship,
He
lordship,
he needs some time, obviously.
lordship, lordship.
Well,
No, no,
it
after
is
two,
possible.
my lord, after 2 p.m. my lord.
See, make a directed study and what are the materials. See the notice aspect also.
Lordship.
That's something. Diary receipt?
Yes, my lord.
Could you go through or
Yes, my lord, I have gone through.
let's wait for him.
Yes.
21.
Your lordship, kindly pass over the matter for some time.
May it please your lordship. Here FIR, your lordship will get at page 17A, lordship.
No, tar, no, no.
Just a minute. The thumb impression issue, no?
Yes, thumb impression issue, and also your lordship will see in the first paragraph that he was arrested on the
Just a minute.
intervening.
I'm just seeing my last order.
Lordship.
Actually, you are submitted by video conferencing, no?
Lordship.
On the last day.
Last order dated
Ah,
26/9/24.
Oh, we had called for a report from the
Report,
court, no?
yes.
For the regarding the inquiry.
Yes.
Okay. Oh,
That report not.
you
yet
wanted
received.
to show me something? Which one?
Yes, first paragraph of the FIR, your lordship will find that he was arrested
At
on
page?
page 17A, lordship.
Para?
First paragraph of the FIR.
Hmm.
This is to inform you that on 6/7/2025, at about 12:30 AM, information received from source through OC Karimganj PS that a person namely Jahangir Alam Chaudhary and his wife Dilwara Begum were dealing and selling of illegal narcotic contraband. Accordingly, a entry was made by PS GDNT number 30 dated 6/7/2025, and he was brought at the PS for interrogation about the narcotic contraband. So he was taken into custody, lordship, on the intervening night of 6th or 7th, lordship, at 12:30 AM. And he was produced before the magistrate on 17th at last hour, lordship. That is after more than 24 hours.
Mhm. Okay.
And that too, Lordship, and when he was arrested, he was not produced before the magistrate. Wife of the present petitioner filed a complaint before the Chief Judicial Magistrate, and thereafter he was produced, Lordship. And the other aspect regarding thumb impression also already your Lordship is remembering, Lordship, that they have manipulated those documents, Lordship.
Allegedly.
Allegedly. And prior to that also, Lordship, that
Yeah. but
another
otherwise,
aspect, Lordship, may I
lots
kindly
of
see.
Yaba tablets, anyway. But that's not
He was produced before the magistrate and his Lordship custody was sought for by the investigating officer, but that was refused because Lordship, he was tortured during this 2 days period, Lordship. That your Lordship will get page 21. Page 21, that is the order. Third paragraph, your Lordship may kindly read that part, how he was tortured. And therefore, police remand was refused by the trial. And there now another aspect I am showing to your Lordship, prior to this also, Lordship, he was arrested by the police of the same PS. That Lordship may kindly see page 42, that is the court's order while releasing him on bail. How he was tortured in that case also. Page 42.
The learned court below has taken some steps regarding the same custodial violence.
That direction was given in that case, Lordship, and thereafter that
To call for a explanation and then
explanation.
necessary
Yes.
refer it to spec.
That is separate case. The page
Separate
42 is
case.
a separate case, but still I am placing that because that is
42.
page 42. Top portion your Lordship will get, the accused Jahangir Alam Chaudhary has been produced before me in connection with criminal case number so and so. Now Lordship may kindly see that he alleged about torture, and regarding medical document, page 44, top portion your Lordship will find. There was manipulation in that medical report also, and his regarding his arrest, Lordship may kindly see that specific part. Page 45, Lordship, why he was arrested, because he lost a case against the IO, therefore he was arrested. Page 45. Last portion your Lordship will get, the following questions were put to the IO. Lordship, page 45, last one. Why arrest was necessary? Answer. The IO stated that the accused has been evading arrest since the lodging of the case. He does not have much information about this case. There was a previous IO who investigated into the case. That is the main case. Now, page 46, Lordship may kindly see. Given the facts of the case, why was the arrest necessary? Answer. The IO stated that the person had lodged a case against the officer in charge of the Thana. Apart from this, the IO could not furnish any other reason. It seems to me that there is no reason why the accused need to remain in custody. Is there any reason why his custody will help the investigation? The IO answered that there is no necessity for the continued detention of the accused for this investigation. If needed, indeed, the custody is not necessary for the investigation, why did you have to arrest him? The IO could not answer anything to the satisfaction of the court. Then in down below that materials were discussed, there was no material at all. So he is continuously harassed by that police station Lordship.
Serious matter, actually. Anyway,
And in fact, a present case also, Lordship, from the FIR also, your Lordship will get that he was arrested in the intervening night of 5th and 6th, Lordship, and he was produced on 7th. That is their documents, Lordship itself shows that he was arrested on 7/1/25 formally. That is at 1:30 PM, page 59 and page 17A I am comparing, Lordship.
scan copy has been received, right?
No, it's case diary.
Case diary is
So
received.
investigation is going on.
Case
Case diary has been
Case
received.
diary.
Okay, along with the report.
Report is
from-
not received yet also.
on the, this thing, because
Report was as per our official also report is awaited to.
we need the report, the urgent matter.
On second ground also, Lordship, may I consider my bail appeal because he was not produced within 24 hours of his apprehension, Lordship.
And what about the notice aspect, the thumb impression aspect?
That Lordship already directed to obtain that scan copy that not received, Lordship.
That's not, that's the subject of inquiry.
Yes, inquiry.
Can we make any determination, no, with, since inquiry is pending, it will not be wise for us to make any determination on that, no?
Without
Consider the
going to-
aspect of bail.
Yes.
Can
without
we
go-
go into that aspect,
without-
while considering the question of bail, or should we wait for the inquiry report?
Wait for inquiry report then.
Because that may take some time, Lordship. That
But
is.
this is, little problematic.
Because from the case diary, if my learned friend can, Lordship, revert that part, Lordship, if he was produced, whether he was
Kindly,
produced.
show me this, this area of the, this notice aspect.
Notice, Lordship, may I kindly see, page 55,
55.
page 55.
Hmm.
That is the thumb impression of the father, and father filed an application before the district court that he is a literate person and he knows how to signature. That is not his signature. So paid for sending that document to the FSL, Lordship. Accordingly, the learned session judge directed the CGM to conduct an inquiry.
Inquiry.
Here thumb impression is there.
It can be sent to FSL.
Yes, that can be sent to FSL.
So this kind of manipulation cannot be accepted.
Cannot be accepted. And in fact, when
You're
page,
not following, you're not following. Next time you follow, but you cannot manipulate.
yes, because Lordship, my wife filed an application before the CGM that I was taken into custody on 5th night and I was not produced before the magistrate. So hurriedly they have produced me before the court. And in fact, page 59, Lordship, may I kindly see, they have formally arrested me on 7/7/25 at 1:30 PM. Whereas FIR says that I was arrested on the intervening night of 5th, Lordship, that 12:30 AM. That itself is a ground for bail, Lordship. I am relying on a coordinate bench decision, Lordship. Lordship,
He was arrested on 6, intervening midnight of 6, 7.
5th and 6th.
5th and 6th. And
5th and
produced,
6th.
5th and 6th and produced on,
On 7th, last hour, Lordship. Because their document shows that I was formally arrested on 7/7/25 at 1:30 PM.
which is the document?
Page 59,
47.
yes.
7/7/25, 1:30 PM.
1:30 PM. That is more than 24 hours.
But these grounds of arrest are also, detailed grounds are not there.
Detailed grounds on the next page, yes, here. We have-
Probably I was not furnished to that. Probably it will be
But
the
the case there is here, detailed.
It is there,
Yes.
but the thumb impression issue is there.
Thumb impression issue and within 24 hours issue.
1:30, no?
Yes.
And the arrest memo, kindly help me with the arrest memo. Yes, let us see it clearly.
Arrest memo, I could not annex here, Lordship.
It is there in the case diary.
Yeah.
Kindly tell me the date, date and time of the arrest. Date and time of the arrest. Intervening night of 5 and 6.
That is from the FIR itself, it is clear.
7/7/25, 1:30 PM.
No, that is the,
Arrest memo, in the arrest memo also.
That is a formal arrest.
date and time of arrest.
Yes.
Date
Page
and time of arrest.
7, okay.
1:30 PM,
No, this is the thing.
more than 24 hours.
No. He was arrested on,
Arrested on 7/7/25.
they're showing a 7/7.
No, Lordship may kindly say that my submission for Lordship is that
He was detained
he was detained
without arrest.
without
Which
arrest.
is actually
So that they have to.
not permissible. actually.
Yes,
But
not permissible.
on record, on record, the date of arrest is shown as 7/7.
Yes,
No, if
And
not-
7/7 at,
1:30 PM.
and he was produced before the magistrate at,
on 7th, Lordship,
on 7 itself,
7.
in the late hours.
late hours.
So according to the records, it is within 24 hours.
No,
This-
from the detention, Lordship, that FIR itself says that he was called to the police station and thereafter he was detained. Page 17A. First paragraph, this. On that night itself, he was interrogated at
Well,
PS.
actually, a person can be called for examination. It's a very gray area, actually. Person can be called for examination without arrest.
He was
After he can
interrogated.
be arrested. But detention is actually that the Honorable Supreme Court has so many times is
No,
saying,
but-
there's nothing like non-arrest detention.
No,
Preventive detention is different.
even
He has
if
to
I-
be arrested.
Yes, even in fact, if your lordship see that after completion of formalities, page 18, last part,
They've messed up, it seems, everything. Page 18.
yes. Last part. In one part, this is 12:40 PM and then again said, let's say 1 AM. But in spite of that, on the same day, he was not produced before the court. If contrabands were recovered, they could have arrested me on same day.
Report, when can we try? Because otherwise, we may even have to consider interim for him, because there are some, lot of infirmities. Lot of, the IO is prima facie, his conduct is not, not good.
Report for lordship,
Thursday? But this is from the
It is
court,
from-
right?
this from Sri Karimganj.
This is from court. They can send it electronically by email.
Lordship, might fix it on Thursday, let us try, Lordship, because otherwise this is a serious issue if documents are manipulated by the investigating agency.
Definitely.
Only 3 days left, lordship, next week.
No, that
23rd or
direction of the session judge was of Lordship 2/9/25. So by this time, they could have Lordship obtained that instruction. Because page 57 is the order, 2/9/25, it was passed.
Both the 47, 48 notices there, no? Or
Yes.
notices are there.
Notices
But
are,
the term impression is there.
yes. Because they have not served any notice to my family. Only after lodging of the complaint, they hurriedly manipulated those documents and produced before the court. Because they kept me in the police station and they tortured me there. That is reflected in the judicial order also.
So 23rd or 24th, lordship, we get.
22nd, can you wait 3 days, 4 days? Can you wait for a few days? 23rd? Well, I wanted to dispose this of. Provisions also will have to be made. Anyway. Yeah, Ahmed Learned Counsel addresses the court on several aspects of the matter in this bail petition. Submitting that though the father of the petitioner is a literate person, is a thumb impression was taken and for which he has submitted before the learned court below for a forensic examination. An inquiry regarding the same is also pending. Full stop. An inquiry report was called for, but not yet received today. Case diary is available, right?
Available.
The case diary is available, full stop. Drawing attention to, this is for remembering, I will remember that. Drawing attention to the relevant orders passed by the learned court below. It is contended that there are also reference to custodial violence. Another submission is that the accused was detained without arrest on the intervening night of 5/6/2025. 5/7/2025. And thereafter produced before the magistrate in the late hours of 7/7/25, thereby exceeding the period of 24 hours. In the arrest memo, however, the date of arrest is shown as 7/7/25 at 1:30 PM. The prima facie, the materials revealed raises some concerns, which might have to be addressed on the next date, on the next or subsequent date. Issue reminder for the while retaining the case diary, issue reminder for the report from the learned court below. We can take a chance on 17th or then thereafter 23rd
Lordship,
or 23rd
17th, we'll take a chance.
on the court. No?
Lordship.
What do you suggest? 17th will be difficult for you.
Difficult 23rd.
23rd, okay. So this is, I'll remember, if I'm in the same roster, I'll
Right.
remember this, or whoever is there, you'll.
All right.
One.
51. May I please, your lordship, my lord, here in this case, lordship, an FIR was filed on 11/3/2021, lordship, with some allegations, lordship. Thereafter, I was arrested and, lordship, honorable trial court, lordship, thereafter on 13/5/2021, lordship, enlarged me on bail, lordship. And then, lordship, charge sheet was submitted and I appeared again before the, on issuing summons, lordship, I appeared before the learned trial court. And learned trial court, page 23, lordship, granted me regular bail, lordship. And I appeared for trial, lordship. But in the meantime, what was happened, lordship? The case was pending for CC, lordship. And I went to Itanagar for my livelihood. There, lordship, I working as a helper of mason, lordship, and fall from a 4-story building, lordship. And due to severe injury on my head, lordship, I was admitted to the Itanagar hospital initially, thereafter referred to the Assam Medical College, lordship. And in the meantime, lordship, the NBWA was issued to me, lordship. Subsequently, lordship, on 12/8/2025, lordship, I surrendered before the learned trial court, lordship, with a prayer, which was also, page 36 is the order, lordship, 12/8/2025, lordship, wherein it was recorded that I have produced all the records, lordship, and I was due to fallen from the 4-story building, lordship, due to several fracture and head injury, lordship, I could not able to appear. But I was taken into custody, lordship, due to NBWA, lordship. And since 12/8/2025, lordship, I was behind the bar, lordship. So I may be allowed to continue with my lordship bail as I was on regular bail earlier, lordship.
I appreciate your submission, but.
Can it be called for that is not received?
The notice. Have you taken the notice? Have you taken? steps?
Yes, lordship, I have already
Taken.
taken, lordship, steps.
Just see the office note. Service, both are awaited, actually, both are awaited. So we'll have to wait for some time.
Lordship, in such case, lordship, perhaps the informant would not appear, lordship. So your lordship may. Notice may be served. Yeah, already.
No, the informant does not have to appear. Law does not compel you to do any case, conduct any case.
Yes, sir.
From your side, only notice.
Yes, lord, I have already taken.
So, wait, so scan TCR, you need the TCR, scan TCR.
Yes, TCR.
TCR is
Actually, entire thing is not necessary. Scan CD and charge sheet. Right. Deposition also?
the deposition it is not, I can, charge is not friendly at all.
No, also charge is not friendly. The scan record not yet received. Issue reminder for the same. Full stop. The response, service upon respondent number 2 is also awaited. The prosecution, you'll take instruction?
Yes.
The prosecution shall take instructions regarding the service upon respondent number 2/informant. List the matter on. Next week,
24 or 27 or something.
27?
27.
Obliged.
May it please your lordship. Lordship, this is a regular bail application, lordship. This present petitioner in jail custody for 28 days, lordship. Intermediate quantity, lordship, 36.41 grams, lordship, heroin. That too recovered from the 2-person, lordship, narrated in the FIR, that is on page 13. It is recovered from Aminur Islam and Joinal Abedin, lordship. And third accused, though, lordship, mentioned in the FIR, lordship, is Habibur Rahman of Borpeta. Nothing else, only this much, lordship.
FIR is on page 13.
Page 13, lordship. And the person from whom, lordship, this has been recovered, they said they have purchased it from Habibur Borpeta, lordship. After that, Lordship, police as such, nothing has been found from the present petitioner, Lordship. Only because of the mere statement of the Lordship arrested person, this petitioner has been arrested, Lordship, and languishing behind the jail for last 28 days, Lordship. Since, Lordship, it is an intermediate quantity, Lordship, 37 rigor will not come, Lordship.
Diary has been received, right?
Yes, Lordship.
So this aspect you have to
Yes,
see
Lordship,
actually,
two persons were arrested,
what are the materials apart from their statement of co-accused?
There is only the basis of the co-accused statement, arrested accused. Aminul Islam Mondal, he stated that he bought the contraband from this petitioner, Lordship. And then it was sent for FSL. FSL is pending, Lordship.
Even, Lordship, considering the FSL is positive, Lordship, nothing has recovered. If a recovery is from this present petitioner, Lordship, burden will lie upon this petitioner to prove that, Lordship, it is illegally or legally obtained that, Lordship.
Very difficult to track these things actually. They have to see CDR. Only co-accused, of
Yes,
course, at the trial it cannot be used. Bail, automatically it will not be entitled, because the investigation is a emerging matter.
As per
It
analysis,
always emerges,
as per CDR,
at the particular stage.
Even
the
the
only
CDR
co-accused statement is there. Of course, there can be a strong argument that
CDR
as of now I should get bail because only statement is co-accused. But subsequent investigation may reveal some other materials also. Of course, at the trial stage, everything is complete. So only co-accused is not sufficient. Settled by Tufan Singh.
Yes, Lordship. Tufan said subsequently, Lordship, I have the, Lordship, there is one of the judgment from the Jammu and Kashmir, Lordship. It's not only for perusal purpose, Lordship, for any purpose, Lordship.
Other High Court judgments also.
Yes,
very
Lordship,
useful,
not
very
only for
useful.
perusal purpose, that is word by, Lordship, 27 of the, 26 of the evidence. Subsequently, 27, Lordship, nothing.
Any good judgment is useful. It's part of our scholarship.
Regarding CDR also, Lordship, there is a para.
Ajay, this, it has progressed, that means investigation has
yes,
progressed.
progress.
Only FSL is required.
FSL is,
Then I think we can allow. Then we can allow, I think.
as per his statement, he knows arrested petitioner.
Maybe
Aminul Islam,
is involved, but that's
that's why he came to his office.
going by the legal position. There's no problem. The Chaudhary Learned Council, State Bank, you kind of, no. Will not. 483 BNSS application. Seeking bail for accused Habibur Rahman, Manikpur PS case number 102 of 25 under section 21B29. The case arose out of FIR dated 27/8/25, where two persons coming in a vehicle, FIR named persons coming in a vehicle were intercepted, and upon checking heroin of approximately 36.41 gram within bracket, falling in the category, bracket of to ward of actual bracket, falling within intermediate quantity, falling in the category of intermediate quantity, was seized from them. It is stated in the FIR that these two persons stated about purchasing the contraband from Habibur Rahman, the present petitioner. Case diary has been received. It is submitted by learned additional PPDP Goswami fairly that the investigation has progressed and seems to be pending only for FSL report. It is also submitted that apart from the statement of co-accused, so far he has not noticed other incriminating materials against the present petition. right? You have not noticed. That's statement about, because I might have missed something, but you have not noticed whatever you have checked properly. So, in the given circumstances, I think it would be justified to grant bail to the accused at this stage. Accordingly, 30,000 with one suited. Subject to condition number 1, so cooperate with remaining investigation. Number 2, shall not hamper or tamper with evidence. Number 3, he shall not misuse his liberty to commit any illegal activities or offences.
The satisfaction of Special Judge Bongaigaon.
Yes. Satisfaction of the concerned learned court within bracket. Special Judge Bongaigaon.
Highly.
Can I?
Yes,
I'll give it back to you later. Just flip through once. What's up, Leland?
Yes.
But in this case, I think last time it was submitted, charge sheet submitted. Only question also see whether 90 days or beyond 90 days.
We had taken up yesterday, this one. Oh, no,
No, not that.
another matter.
Oh, no, sorry, madam, sorry. Oh, sorry, madam. This is another case, madam.
Oh,
Yes, this
that
is
is-
matter actually
that
compromise.
fixed tomorrow, I think.
Yes, that was tomorrow. This case matter actually, they have already entered in compromise. And compromise petition, we have additional, evidence. Just today morning it was mentioned and it is brought to your worship, madam. And private parties also appeared, madam. Your Lord, kindly see the additional affidavit filed today, madam.
You have appeared, no, for the notice. Private counsel.
Marriage, what you see? Yes, marriage took place on 5/5/25, madam.
Just.
She is willing to come, only informant might have initially prevented her. That now he has also might have convinced and they have settled out of that.
This can be considered for the purpose of bail, it can be.
Yeah.
considered. Otherwise, your submission.
Initially, my lord, I had some problem with my lord, the boy.
Mhm.
Now, my lord, we have my lord,
But she's still a minor, right?
No,
my
no,
lord,
no,
She's not a minor.
not one, not
But
one.
no, in any case, we can.
She is
take-
major, now she is major.
No, in any case, we can take this into account for the purpose of bail,
Ma-
though it will not be compoundable as a
Madam.
case before the trial court. Charlie Chaudhary, learned senior counsel, assisted by I.U. Chaudhary, counsel for the petition. The petitioner invoking section 483 BNSS seeking bail in connection with Gauripur PS case number 260 of 25, in which he is in custody since 14/6/2025. CD was also called for.
The charge sheet filed, madam.
It is submitted by the prosecution that charge sheet has already been submitted in the case. A learned counsel also appears on behalf of the informant slash respond number 2. Full stop. An additional affidavit has been filed in which annexing an agreement, and it is stated in the additional affidavit that just a minute.
Paragraph 4, madam. Page 36.
Yes, I've got it. Petition will bring on the court. I'm the younger brother. It is stated in para 4 of the affidavit that in the settlement, in the supposed settlement, the petitioner, the informant has not objected to the grant of bail, the petitioner. The learned counsel appearing for the informant supports the said contention. In the given facts and circumstances, the said aspect can be taken into account, perhaps for the purpose of bail. And also accordingly, in view of, in the aforesaid facts and circumstances, and also keeping in mind the length of detention, dash of the the accused is allowed to go on bail of rupees 25,000 with constitute minus, like subject to the condition. He shall
Special judge Dhubri, madam.
concern learned लिखे ना गौरीपुर to the special judge Dhubri.
A special judge, yeah, additional session judge come a special judge. A special judge will do, madam.
He will
Do
not hamper or tamper with evidence, and he shall cooperate with the process of law.
Obliged.
Supply to me.
My place, your lordship. Well, this is a regular bail application, charge sheet case trial is going on. Now present stress is the evidence test, my lord. My lord, date of arrest, my lord, 16 February 2023, my lord. As on today, my lord, 2 years, 8 months is completed behind the bar, my lord.
16 February
16 February 2023, my lord.
23.
23, my lord. As in today, my lord, 2 years, 8 months is completed behind the bar, my lord.
And
My
not,
lord,
it will be 25, I think, 16/3,
yes, my lord, 2 years, 8 months.
or 2 years, 8 months.
Yes, ma'am. 2 years. My lord. My lord, kindly see the page number 63, my lord. Page number 63, my lord. Annexure number 9, my lord. It's a very important, my lord, genuine ground, my lord. They are under treatment, my lord, inside the jail, my lord. And order was passed, my lord, by the additional session judge number 1, my lord. They should treatment, my lord, outside the GMC, my lord. This is a very critical condition is going on, my lord. Since, my lord, 16 2024, my lord. It's very necessary, my lord. It is needs to treatment outside, my lord. There are critical conditions going on, my lord. Both petitioner, my lord. Page number 63 is annexation 9, my lord. Another ground is that, my lord, notice under some 50, my lord, at the time of arrest, my lord, the ground has not been mentioned, my lord, in the said notice, my lord. I have annexed also, my lord, that notice, my lord, by filing additional.
At, is it there? The page, additional affidavit.
Yes, my lord. Page number 81, my lord. Notice under some 50, my lord. Notice issued, but ground not mentioned, my lord, in the notice, my lord. My humble prayer, my lord, the long detention is going on, my lord. And my lord, there is a witness, my lord, 15%, my lord. Out of it, only 4% examined, my lord.
4 out of 15.
Yes, my lord.
Out of 8.
Long
So,
detention, my lord, going on, my
We
lord.
call for the scan record.
All the available, my lord. Scan copies are
Been received. Lord.
yes, available.
Can I go?
Kindly consider, my lord, kindly
Okay.
consider. Yes.
So your lordship contraband recovered from their possession, lordship. Petitioner number 2 was the driver and petitioner number 1 was the co-driver, lordship. And lordship, here lordship, 4 witnesses have been examined. Out of lordship 8, I am not
15,
confident,
I think.
lordship,
They said
Yes,
15.
madam. Yes, madam, total.
to check in the
Oh.
record, lordship.
But let's take this notice will not do. 50
Yes.
notice is
Here at the-
inadequate.
Lordship, at the time of his arrest, they accepted arrest memo, and in arrest memo, lordship, their signature was there, lordship.
That's
It is
proven,
there on
but
record,
ground has no
lordship.
mention.
And this
Arrest memo is there. Here is
arrest
there.
memo.
No, my lord, the notice under section 50 is there available, my lord.
Yeah, it is
I have an
actually-
explanation.
That arrest memo, lord.
Now, of course, in that time, it was this law had not come.
Yes, lordship.
But it was now
Long-
retrospective, so
Yes, ma'am.
he can get benefit. Otherwise,
Correct.
even held ground is very difficult to
madam.
consider vis-a-vis 37. There is there's one judgment also of the
Yes,
High
madam.
Court, our High Court, but Article 21 comes.
Yes.
But even in case of held grounds also, if 37 applies, then sometimes it is very difficult actually to overcome that. Any case, but here, thing in your favor is the notice, actually. Otherwise, so if the notice is defective, then we need not even go into the whether 37 will be applicable. We need not go. Then we'll have to see inside whether it can be said that he's not guilty. Then we need not go into that. This notice, the scan copy, can you flag that notice? Same notice which was given here. Does it affect? Can you just take out that notice from the record?
Lordship.
And I'll just tally it with this for formality.
My lord, I have annex my lord, certificate
sir.
copy, my lord, of the notice, my lord.
At page 81.
81, my lord, yes, my lord.
Certified copy.
The certificate copy, my lord. I have available, my lord, the certificate copy also.
They are from outside Assam, this.
No, my lord, inside Assam, my lord, Karbi district, my lord, inside Assam. Both are, my lord, both are.
Kindly have a look, huh? Just if you can locate the notice. Meanwhile, I'll just drag the facts. This is acceptable because this is a certified copy. But
Yes.
just for satisfaction. Rahman Learned Counsel for the petitioner and Learned Counsel, Standing Counsel,
Lordship,
Learned Counsel.
I'm appearing on behalf of SCK. Lordship.
No issue. Learned Counsel, appearing for the Customs Department,
Lord-
representing the Standing Counsel, SC Coil. The present accused, who is stated to be in under trial detention since 16/2/2023, has invoked section 483 BNSS to seek bail in connection with NDPS case 118 of 23 under section so and so, corresponding to NCB crime number 2 of 23, pending before the court of the learned additional session judge number 1, Kamrup Metro, Guwahati. Two petitions. Considering the penal provisions of the NDPS Act given, the applicability of section 37 has to be checked per se. However, the petitioner side has filed an additional affidavit taking the ground of non-compliance with section 50 CRPC within a bracket as it existed then, pertaining to furnishing of grounds of arrest to the accused. 50A is not there.
No.
Family member is not there. It is also submitted that the notice under 50A CRPC is not available at all. The scan copy has been received. Scan record, case record has been received. It is also submitted by the petitioner side. Referring to Annexure 9 about the health problems of the accused persons. Health problem of petitioner Joy Kumar Chauhan.
Joy Kumar Chauhan and Wal Chauhan.
No, one person is suffering from illness. Anyway, this is secondary actually. We have to be going for the notice. Do apni uthai di, no? The learned standing counsel, the learned counsel for the prosecution submits that so far 4 witnesses have been examined during the trial. Out of the 15 listed witnesses. The prosecution points out the serious nature of the alleged offences. Falling offences under the NDPS Act, falling in the bracket of commercial quantity. The notice furnished, the notice furnished to the accused under 50A, we reproduced herein below. If I remember. It is clear from the said aforesaid notice that it does not meet the standards and requirements laid down by the Honorable Supreme Court in the case of Bihan Kumar. As detailed grounds and grounds specific to the accused have not been narrated. Full stop. In terms of the law laid down in Bihan Kumar, Supra, full stop. The said infirmity at the time of arrest renders his continued detention untenable and entitles the petitioners to be granted. So this notice is, what is it? 50 notices with regard to Jay Kumar Chauhan. Another one is, where is the other notice? Other notice is there?
Chair, I have flag marked everything. Arrest memo, intimation letter of section 50 notice, I have flag marked everything.
This is Jay Kumar Chauhan. With regard to the other petitioner, you have not annexed the notice.
Records
Just
regarding Wal Chauhan.
must be the same, but I want to just check it again once. Bhual Chauhan.
Yes, ma'am.
Second petition.
Oh, this was the earlier format actually. This was the earlier format. কি লিখলো last photo? Oh yeah, লিখিলো. It has been also held in Bihan Kumar Supra that such entitlement to bail due to such infirmity in arrest procedure would prevail even if there is some statutory restrictions on bail in the given law. Therefore, in a manner, it will be a futile exercise to go into the detailed materials as to whether the rigors of section 37 NDPS Act would be applicable in an instant case, as the petitioners have found to have become entitled to bail in terms of the said law due to fatal procedural infirmity at the time of arrest. In such view of the matter, I'm allowed to go on bail of rupees 75,000 with one surety of the like amount each to the satisfaction of the concerned learned court. This is additional session, just number one.
Yes, madam.
Number one,
Kamrup Metro.
and the following conditions are imposed. Number one, they shall be available for the remaining trial. Number two, they shall not hamper or tamper with evidence. They shall not misuse their liberty to commit any offences, including any offences under the NDPS Act. Bail petition stands allowed and disposed of.
Duly placed, duly placed.
That's true.
And being 19.
What did the time is?
I'm sorry, my lord, I was not there in time.
No, it's okay, no.
My lord, if your lordship turns to page 20, my lord. Page 20, my lord, second paragraph, my lord. During the course of investigation, it has been revealed that the accused person, namely Dharmeshwar Roy, alias Jitu Roy, alias Ajit Roy, aged about so-and-so, had so-and-so resident, has committed the offense of cheating and criminal breach of trust by fraudulently inducing the informant and his son to deliver a Maruti Suzuki Ciaz car registered number so-and-so along with an amount of rupees 3,50,000 under the false pretext of purchasing a new vehicle and thereafter absconded with both the vehicle and cash money. This is the FIR, my lord, gist of the FIR, because the FIR is very long, my lord. Now your lordship will turn to page 25. After his arrest, my lord, he was produced before them as the magistrate, my lord. Page 25, second paragraph, my lord. Perusal, may I read, my lord? Perusal of the case diary reveals that the present case originated from an FIR lodged by one Abhijit Das, alleging that the accused Dharmeshwar Roy fraudulently induced him to deliver a Maruti Suzuki CS car and a sum of rupees 3,50,000 under false pretense, and later absconded with both the vehicle and cash. During investigation, the accused was traced to West Bengal and the communication was established with the Vaishnavnagar police station. Acting on the information, the concerned police personnel intercepted the accused during Naka checking. It is alleged that the accused attempted to run over the police personnel and during the chase fired upon the police party. The accused person was thereafter apprehended and produced before the CJM Malda, West Bengal. Next paragraph, my lord. Considering the materials available in the case diary, the prayer of the IO for shown arrest of the accused person in connection with Latasil PS case number so and so, registered under section, my lord, this is important, my lord, 61(2) small a, 318(4) of the BNS is allowed. Now, my lord, the next page, my lord, page number 27, my lord. So two more sections have been added, my lord. Fourth line, yes, my lord, answer. Now, my lord, the petitioner in the instant case has been arrested, my lord, on 11/8/2025.
Shown arrested.
Shown arrested, my lord. So now, my lord, today.
Our case is Lotasil PS.
Lotasil, yes. So today is 64 days, my lord. So otherwise, my lord, the mandatory period is over, my lord.
Is it? Anyway.
And moreover, my lord, now.
All the, these arms act sections are also 60 days.
Yes, yes.
Regarding one, my lord, organized crime is there, that is added, that is, my lord, 90 days offense, my lord.
One is 90 days.
11(2), I will point out, my lord.
1111(2), no?
Yes, yes.
1111, yes, my lord. Now, my lord, the question, my lord, of your lordship says, my lord, 112, my lord, in the BNS, my lord. From the magistrate order, my lord, 111112, my lord, that is not there, my lord. Lordship, may kindly see 111, my lord, organized crime, my lord.
Organized crime.
Organized crime. Any continuing unlawful activity including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offense, cybercrime, and trafficking of personal drugs, weapons, so and so, my lord. These are, my lord, organized crime, my lord. Now, in the instant case, my lord, the section which has been inserted, my lord, 111(2). The 111(2) says, my lord, whoever commits organized crime shall, if such offense resulted in the death of any person, be punished with death or imprisonment for life. If such offense has been resulted in death of any person, my lord. Whether this section is attracted to me, my lord.
Or any other case.
Yes.
2B may be applicable.
Yes, madam. B may be applicable. So far, my lord, 111(2).
This may extend to life.
Yes, madam.
You are saying in the context of statutory period? Are you saying in the context of statutory period?
Yeah, other, my lord, 60 days.
But, don't you think that even if 2B is applicable,
Madam.
since it is up to life, it will still be 90 days?
90 days.
What do you think so?
Yes, madam. Now, from the, my lord,
Anyway, so
yes, madam. From the
before I come to him,
yes, madam.
you
From-
kindly
yes.
complete.
From the magistrate order, my lord, that 100,
It has not reflected.
it has not reflected.
There are so many subsections now.
Yes, my lord. Now, my lord, I'm not on the merit of the case, my lord. To be fair enough, my lord. If a lordship turns to page 38 for a once, my lord. Page 38, my lord. Last line, my lord. Features are suggestive of left inguinal hernia, my lord. My lord, this is, my lord, below your lordship will see, my lord, 3rd of September 25, my lord. Now, my lord, the present petitioner had number of cases, my lord. Two cases are, was there today, my lord, in court number 22, my lord, as item number 10 and 13, my lord. Today, my lord. And that has been moved, my lord, and bail was granted, my lord, not on, my lord, merit, my lord, on one medical ground, my lord.
And detention.
Yes, my lord. Now, this is 38, my lord. This is of 3rd of September 25, my lord. Subsequently, my lord, he again appeared before the medical college, my lord, on 9/9/25, my lord. Lordship, may I have a kindly look at. These documents were annexed subsequently in other case. So he needs, my lord, operation, my lord, that is scheduled on 19/10, my lord. Lordship, the date is there, my lord, and SA means, my lord, SA, my lord, spine with spinal anesthesia, my lord.
Yeah.
My lord, to be fair enough, my lord, the other two cases which I moved, my lord, in the other court today, my lord. So in those cases, my lord, I was behind the bar for in one case 44 days and other case 48 days. So in the instant case, today I am behind the bar for 64 days, my lord. If your lordship feels, my lord, 111(2) is attracted to me, then in that case, my lord, I am praying for interim, my lord. And because in the other cases, my lord, interim has been granted till 7th of November. On 7th of November, I should surrender before the CGM Kamrup Metro, my lord.
Anyway, so but this I think we can dispose of because
Yes,
CD has come.
Yes, I will point out. to you
I'm
that.
not on the merit of the case, my lord. I request my learned PP, my lord, to kindly go through the medical report, my lord, once more. I'm not on the merit of the case, my lord.
Yes. Anyway, my lord, I will point out some of the vital aspects, my lord, regarding medical report because that copy is not with me, my lord.
65 days,
65 days.
64 days.
64 days.
And I would just like to, yes,
last page.
not on merit, but I would just like to point out regarding the my lord, argument that for your lordship, my lord, or not for consideration of the present bail petition, but at the time of, my lord, against the present petitioner at the time of adding section 111 subsection 2, my lord, although now the argument is that, my lord, that provision of section 2 of A is not applicable, but B, then also, my lord, it would come to, my lord,
90 days.
90 days.
True.
I am just, my lord, handing over this earlier order that is rejecting anticipated, not for consideration of this bail petition, my lord, regarding regarding against the present petitioner, there are, my lord, total 11 cases
Yes,
pending against.
That is of concern.
Yes. And thereafter, my lord, on the basis of that, on the basis of the application of the IO, my lord, on consideration of all these grounds, my lord, section 111 to added. And thereafter, in this case, petitioner was shown arrested, my lord. Earlier, he was arrested, my lord, in a, my lord, case which was registered in West Bengal, my lord. And here in this case, shown arrested. Thereafter, again, by order dated, that is annexure 4, my lord, some one live ammunition of 5.56 mm, 5 empty cartridge, 7.6, those things were recovered. Thereafter, arms act also added against the present petitioner. So from the material point of view, there are sufficient material against yes, from the contents of the FIR at the time of my lord argument, while my lord rejecting the anticipatory bail, I pointed out, yes, prima facie it seems from the FIR that it reflects that this is a, my lord, purely a civil case. But after going through the prima facie from the FIR, my lord, he has, well, thereafter, my lord, after
It
going.
may have a civil dimension also, but
it is, yes, I'll point.
prima facie criminal dimension also.
Oh, yes. Thereafter, my lord, after going through the case diary, after receipt of the case diary, my lord, the, my lord, materials, my lord, the while, my lord, finding law, the number of cases against the present petitioner, the modus operandi, how he is involved in committing offences against one after the other, my lord. And those, my lord, persons who were victimized, their statements also recorded by police. And in the case diary, those FIRs also available, my lord. And total, my lord, 11 number of cases at present pending against the petitioner, my lord, against in.
This aspect can be seen like the other two matters,
Yes,
other
ma'am.
two interim bail was granted.
Interim bail till 7th of my lord. On 7th, my lord, I was asked to surrender before the CGF. My lord, one submission, my lord. I'm not against my PP, my lord. He is submitting there are 10 cases, my lord.
11.
11 cases. There may be 10, 15, 20, 100, my lord. But that is the duty of the prosecution, my lord, of the state to show, my lord, how many number of cases are pending. In the forwarding report, they have not mentioned anything about it.
Or bail objection they can show.
Yes, they have not mentioned.
But
I am not on the
relevant factor.
on the interim,
Let
my
him
lord.
have the surgery.
Right.
In fact, my lord, order heading 112, my lord, in that order specifically detailed list of all the cases. is
Yeah,
there.
yeah.
Nine or not for the
That is why they have added this
Yes.
continuing unlawful activity, that is the
Yes,
definition.
yes.
Of course, now case laws will come
Yes, my lord.
on that
I'm
definition
only
of that.
Till seventh, my lord. Yes.
Only on medical.
Addition, the second, first paragraph is same. The gist of the allegations is that the
Page 22nd paragraph.
gist of the allegations in the FIR is that the present accused fraudulently induced the informant to deliver a Ciaz car, Maruti Ciaz car, along with rupees 3.5 lakhs, and absconded with both full stop. He was shown arrested in this case pursuant to his arrest in case in West Bengal. And yet Mr. Dr. Learned Counsel submits that his main contentions are not with regard to merits of the case, but rather the health problems of the accused, present accused. Medical documents have been submitted before the court. And in the context of the same, it is submitted that he has been diagnosed with hernia and advised for surgery on 1910.
Man,
19,
1 9.
on 1910. It is also submitted that with regard to two other cases, the coordinate bench of this court was pleased to grant interim bail to the accused on health grounds till 7/11. The learned additional PP, along with the case, on the basis of the case diary, submits that the provisions of the penal provisions pertaining to organized crime has been rightly added, and that there are as many as 11 cases pending against the present accused. Nevertheless, considering the aforesaid aspect of surgery advised and order of coordinate bench as submitted by learned counsel dash it is directed that in the interim, the accused is allowed to go on bail of 30,000 with one surety like amount to the satisfaction of the concerned learned court, subject to the condition that he shall not abscond and shall cooperate with the investigation. Till 7/11.
Still 7, man. I'll surrender before CJM, man.
The bail is granted till 7/11/2025. And on the same day, said date, the present accused surrender before the learned CJM,
Kamrup Metro.
Kamrup Metro.
And the case diary is fixed on 11th, my lord. Other case.
Other cases.
Other case.
Oh, in this case diary is already received,
Well,
Yes.
but we'll need it for final adjudication. You want to retain it or?
No, Lotus Hill, I will send back. and
Okay.
get-
The case diary may be returned back and procured again on the next day. List on 11.
11.
11/11/25.
I'm obliged. man.
You want this?
Yes, man.
You'll need this. I think.
I'm obliged.
Yeah.
Deeply obliged.
Okay. What's it? 19.
Is it 47?
Still down.
Let me, your lordship.
No.
For a P3 application, lordship, petitioner was arrested on 3/2/2024. Today is about 1 year, 8 months, 10 days, lordship. In this case, lordship, by the additional affidavit, we have taken the plea of non-compliance of section 50A, lordship. This one, this one. Well, we had taken the plea that, their lordship,
In earlier cases, in none of these cases it will be there, because at that time, the IOs did not know.
50, they have provided lordship, but it was in English lordship and they put their thumb impression lordship, not in their own
Almost.
But in 58.
Where is the notice, fifth page?
Lordship.
Is it there?
Lordship, it is in the record, lordship.
It is in the record also.
Record, my
Just a minute, I'll come to you. Just a minute.
One additional affidavit they have filed.
You filed.
Last week, and
Mhm.
we have filed for a reply of that additional affidavit, but it could not be brought in the record actually.
Okay.
There is some.
Oh, they
mistake.
have filed
We have
additional.
the record, lordship.
No, they have, you wanted to, you have filed a reply,
Already, actually, we have filed already, but.
but
there
not
is
come into the
a
record.
record.
It is
Actually,
not?
there is a mistake by the IO. He did not put his phone number there. So it was pending in defective section. So
Okay.
My lord, my lord, what happened in this case, record will reveal all these things. Lordship, it is in the record and this is the certified copy regarding this petitioner lordship.
But the.
But
reply-
lordship, they have denied that they have complied. It is, the record will reveal all the things, lordship. It is in the record, they have not complied. Lordship, this is the certified copy of the Buddha petitioner. Buddha petitioner,
Let
sir,
the affidavit come, we can fix it tomorrow.
tomorrow.
It, can it be on 17 Miller?
My lord, 17 will be too long, my lord.
Because I will check it
Because
and
already
to
already
17,
putting up the number
Maybe
already.
some load also, and also there are 4 holidays. Can it be on Thursday? for you?
Thursday, yes,
Okay.
madam.
Thursday? Just a minute, this is your certified copy, no?
Yes, yes.
You
It
have
is in
been
the
found-
record also,
keep
my
the
lord.
ball in the possession of packages containing.
This is the notice under 50, but 50A notice is not there, lordship, and in both the notice.
This is not completely, bland. It has some grounds.
Some grounds, but
Yes,
lordship,
grounds.
they put the thumb impression, lordship. It is also mentioned in Bihan Kumar, lordship. It should be in own language, that should be described.
No,
in
just
own-
be explained to
They
you.
have
And,
explained
But
through
lordship,
their phone number and
And, but 50A notice is not.
No, no,
they
not
have
at all.
submitted, but not 50A was not written there, but the notice has been submitted.
50A notice not provided to the family members, lordship. There is nothing
Well,
in the
I'll fix
record.
it on Thursday at the
Oh,
reply.
no problem. Don't worry about these factual things, because now people are learning. At that time, it was not there. Nobody knew.
But lordship, they.
But still, considering what was the date of this, 24, 3/2/24, considering the time that at that time the one judgment had just come, this is a good narration, reasonably good narration.
But my lord,
Reasonable, but the other notice also is required actually.
yes,
Same,
if,
actually.
if they know. if-
All they have to do is just
My-
produce it
my
for the
lord, if-
family.
If they know regarding section 50, then they could have issued the notice section 50A also, lordship.
No, people were not, they were learning. Anyway, we'll discuss it on the day after tomorrow.
Lordship.
You kindly take this back.
Lordship.
And you can keep a photocopy, which you
Lordship,
give me on
Lordship.
the next date.
Lordship.
You keep a photocopy on the next date. Otherwise, we had called for case diary or scan report.
A scan report is there, lordship.
Already there, madam.
Report has been received. However, it is submitted by your good name, please.
PS Chakraborty, special
PS
PP for
No. P.S. Chakraborty, special
PP,
public prosecutor, DRI.
dear.
Here submits that the prosecution has filed affidavit reply to the additional affidavit filed by the petitioner side. It has not yet come into the record and may be done so. It's prayer allowed. This is the matter on Thursday, 16/10.
Along with the reply filed by them, lordship.
Along with the replies. Now there will be no justification. Now suppose I make a mistake, I don't give a
Yes.
notice, then it will, because my learning window is almost gone now. Because
Yes.
it has been 10 months. But at that time, but considering the time, this is a reasonably good notice, I would say.
Of that.
May I please, lordship? Well, in this case, my lord, the alleged victim, my lord, at the time of date of occurrence, lordship, above, my lord, 18 years, lordship, as per school certificate, but my lord, in view of my
Our case is, my lord, that simply submitting will not do, my lord. It must be seen by the magistrate. And that is the only instruction, my lord. Today, we already 104 days in custody.
I have received one report, my lord.
The judgment has in,
Amicus has appeared,
judgment has over.
amicus.
Those in the-
Oh, so service is not.
Sahalo Muslim incoming.
Huh?
Sahalo Muslim.
না হজরত আলী
Rotan.
হজরত আলী এইটো হ'ল তোমাৰ চাপৰ মানে দুবৰি বা বিলাসীপাৰা হ'ব নেকি
Okay.
Yes, Sahalo.
No, Salam is the informant, I think.
Informant notice served, my lord. I have just now got the report, my lord.
That is
Notice, sir.
Notice served, my lord.
So we can appoint amicus, I think.
Yes.
3. Only my 2 paragraph 30 and
I'll see.
38, my lord.
Mhm. Just one.
They said when on 90th day, they have filed the charge.
Mhm.
Our case, matter whether it was seen by the magistrate, or that is, you'll kindly see, man. Only when your lordship is having experience on that one.
আমি লিখিছো আমি লৈ ল'বা heard senior HR is heard assisted by Ocho. Okay, এইখিনি একে হ'ব third paragraph একে হ'ব you have received case diary scan so you had called something charge sheet was called scan case diary and charge sheet was called.
No, charge sheet file they have submitted the other day, my lord.
Call for the scan, we had called for the scan, it is submitted by the learned additional PP. That instruction has been received that service has been completed upon the respond number 2/informant. Full stop. However, none appears on his behalf. Accordingly, Surajit Das, learned counsel, is appointed as amicus to represent the informant /R2. Now, it was on 8/10, right? During the vacation code. Probably steps, I don't know whether.
But my prayer is, my lord, default bail. Whether
Default bail.
service is, I am on for default, now default bail, my.
It's a long judgment.
Yes.
So
Well,
Yeah.
paragraph 30 and 38, your lordship.
you have mentioned last.
Yeah, 30 and 38.
Yeah, but
And that is statutory, my lord, so objection is not. Division of judgment.
30 and 38.
38,
38 is the conclusion.
my lord. It is only when the magistrate competent to take cognizance of the offence puts initial in the charge sheet.
Logical, because only then the magistrate to the court will come to know that the
Mild,
charge sheet has been
mild.
filed. Otherwise, sometimes we find that it was filed 1 month back only.
Right.
So we'll not know. So by this analog, by this reasoning, will it logically follow that if it is not seen within 90 days, he'll be entitled to default?
Default
That is
bail.
what sir is saying.
As per the, my lord,
Hmm.
if it is not.
That will be the natural
Yeah,
consequence.
yes, my lord. That's why my this is there. You are the 104 day today, my lord.
That is also there.
Yes.
Oh, but the thing is that amicus.
That is not required default bail, my lord. In my opinion, subject to all the assessment. Default bail, my lord.
In that case, we'll have, because we appointed someone.
Absolutely, so we will say.
Then in that case, we don't have to appoint, you know. So, if we appoint, then we'll have to serve.
Exact, my lord.
Yes,
There is no, because default base statutory right, my lord.
Yes, today is 104 days.
Yes.
In that case, it is not necessary then. Anyway, that's so, I think you're right. Because nothing has to be said on merits.
Exactly.
Regarding that, my lord, otherwise, search sheet কেটে apply হয়েছে নাকি?
Structure খাল তোমাকে এদিন কইছে 90 দিনের ফাইল
Regarding, in my file, my lord, regarding filing of search sheet, when file, my lord, there is nothing in my file. my lord.
But that was a submission made in the other day. Those one also this. What was the charge sheet?
Charge sheet dated please no.
Yes. P30,925 as per the other.
150 of 25. Can you cross check? Yes. The accused is stated to have been arrested on 2/7/2025.
Exact, my.
Stop and has completed more than 104 days, more than 100 days in under trial detention. The learned senior counsel seeks default bail on the ground that the charge sheet which was filed was not placed before and seen by the magistrate within the period of 90 days, within the applicable statutory period of 90 days pertaining to the instant case. 28, 29, 210, right? So, are you in a position to say that he was, that it was not seen by the magistrate? Because right now, my lord, there is nothing. What would be your submission to to help? me
My
with that?
submission, my lord, only on, if it is correct, but it was on 90th day. Submitted charge sheet, but it was not seen by the magistrate. Your lordship may accord my submission, my lord. It was not seen by the magistrate on that day, my lord. Oh, as per instruction, they filed yesterday.
The senior counsel submits that, though the charge sheet was submitted on the 90th day, but it was not placed before the magistrate and seen by the learned magistrate on the 91st day as required by law, and therefore the right to default bail had already ripened, ripened in favor of the accused. In support of the said contention, the learned counsel, senior counsel relies on decision of this court in the case of Samsun Noor alias Samsul Noor versus State of Assam, 2022, 5 GLT 405. A reference is made to the relevant paragraph 30 and 38, which are reproduced herein below. So anything else from your side?
Yes, my lord, otherwise, already, if my lord, already default, he is entitled for default regarding that.
No, that is the determination.
Yes, that
That
is
is
the
a
but
submission.
regarding
Can be
on the
accepted.
day, my lord, that is, if search is submitted on 30/9/2025.
90th day.
The whole day is there. Thereafter, my lord, on that day, what is the order, is the order passed by the learned trial court that is right now not available?
That we do not know.
Whether that was already seen by the trial court or not, my lord, nothing is available, my lord. Not about,
Itu উঠাই দিব লাগিব দুটা
Your
paragraph.
lordship, conditional, my lord. Suppose if it is there, my lord, I am not entitled, my lord. That way also it can be. Suppose if,
Your summation I have recorded as.
my lord.
Or should I not believe it? Anyway, so in that case, I'm in again. It was amicus law. This is right. In the given facts and circumstances, though the charge sheet is dated pre-snow 2025, but in terms of the principles laid down in Samsun Noor Supra, it appears that the accused has become the contention of the petitioner side about entitlement to default bail is acceptable to the court In any case, investigation is also completed and the length of trial detention so far of 104 days is is also significant. In the entire facts and circumstances, the accused so-and-so is hereby allowed to go on bail of rupees 50,000 with one surety of the like amount to the satisfaction of the
Special Judge Bilasipara.
concerned learned court within brackets, Special Judge Vilasipara. Subject to the following conditions. Number two, he shall be available for the trial, if one commences against him. Number two, whether number two, he shall not hamper or tamper with evidence. He shall not intimidate, harass, or annoy the informant / victim or other witnesses. Violation of stand. Bail petition stands allowed and disposed of.
Obliged.
The new kind of bail have passed slightly uniquely. Can I just?
My lord, my lord,
Give it, I'll give it back.
No, not to be returned, my lord. Your lordship.
So you will use it and then you can give it also. You got,
17, my lord, as per my instruction, notice served, my lord, Bosco. Regarding that only relevant aspect regarding 35(3), I have checked, my lord, already notice served, my lord, everything is there in the case diary, my lord, regarding that aspect, my lord. Your lordship may kindly peruse, I have flag mark, my lord. And thereafter, immediately after arrest of the petitioner, my lord, that order is also there, showing sufficient, my lord, reasons, my lord, for arrest of the petitioner, my lord. And regarding, my lord, service of notice, my lord, 35(3). Thereafter, initially, my lord, after serving of notice, my lord, in fact, statement of the petitioner was also earlier recorded on 13/7/25 and 14/7/25.
This is the case diary.
Yes, case diary, my lord. Otherwise, my lord, there are voluminous records, my lord, statement of victims, Sijali, everything is there. My lord. There are sufficient bank
Takes a lot of
statement.
time. So
They are involved in collecting, my lord, more than 50 crores from the victimized persons, my lord.
he was arrested on which date?
Arrested on, my lord, 22/8.
21/8, your lordship.
21/8.
55 this lordship behind my law.
Demanding.
55 this.
Your marked the notices are here only, no?
Regarding, my lord, serving on notice.
Those 35(3) notices are
35
proper.
notice, yes, my lord, regarding 35(3) notice, my voluminous record, regarding part of the notice that
Compliance is there.
compliance is there, my lord, that is note of the IO. Thereafter, my lord, he appeared before the IO on 13/7, 14/7. His statement initially recorded. At that point of time, he was not arrested, my lord. And statement of the petitioner, my lord, recorded on 13/7 and 47 is also available, my lord. I have flag marked. And it is specifically noted down that 35(3), my lord, notice served. And in this case, my lord, in forwarding report also, my lord, otherwise also there are sufficient grounds, my lord, has been mentioned, my lord, why the petitioner was. I in fact, my lord, talked to the investigating officer also, my lord. He also confirmed that, my lord. Statement recorded on 13/7 and 14/7 earlier, my lord, before his arrest, my lord. That is also available in the,
What is this bullseye trading?
That
What
is, my lord,
what
one-
do they do actually?
They are actually, my lord, by opening that, my lord, company, they collected huge amount of money, my lord, from the various victimized.
For
persons
investing in
in the
stock
name of
markets.
investing in various businesses, my lord.
For various businesses.
Businesses,
Not
yes.
stock markets.
Thereafter, my lord, my lord, in this way, they procured huge amount of wealth, my lord, regarding that aspect, my lord, some of them available.
Promising high returns.
Yes, yes, those, total, my lord, more than 50 crores, my lord.
People also foolishly believe
Yes,
actually.
they are
Money does
speculate-
not grow on trees, no?
Yes,
It's
yes.
hard earned, for most people.
In spite of knowing all these facts, my lord, again and again, my lord, these persons are investing money in these companies, my lord.
You are paying for two of the victims.
Victim, my lord.
One victim.
One victim, my lord. My lord, by is the name of this Bonsai company, my lord. This is a fake company. So by creating this fake company, my lord, they are collecting a huge money from the, my lord, people, my lord, innocent people, my lord. But in the name that they will invest the money for trading money. With a high return, my lord. And my lord, monies were collected from their, my lord, personal account.
Organized crime offense, bail provision has been given.
No, my lord, those.
The statutory period is 90 days.
60 days, your
Second
lordship.
period is, my lord,
60 days, your lordship.
That also aspect has to be seen.
Oh, may I submit if
And
lordship?
I'll come to you.
Lordship.
9, 2110. Anything you want to say on your side? You want to submit any?
Yes, my lord, from the materials, my lord, and, my lord,
Because otherwise, on merits, it is
Yes.
not,
not a fit case.
yeah, I think it's. Are you sure it's all 60 days, no? Did we cross check?
Yes, your lordship, 7 years imprisonment, your lordship.
No, that statutory period has been in a way made very mechanically, because some things need a lot of time to investigate.
Yes.
Otherwise, the same section, no additional section has.
But anyway, but
Original-
whatever is the law, we have to follow. That's
Uh,
the-
Yes, your lordship.
Yes. My lord, if any addition is there, my lord, sometime, my lord, I will contact
You
the
just
IO.
check it, but
Because-
otherwise 61, 2, 3, 380, but you would know, no new sections.
No new section, your lordship,
Existing
because
one.
they have to
Existing.
inform the petitioner before
But
adding a
cross check once, anyway.
check a section, your lordship.
Because
And
record is
the-
voluminous, so my lord, probably if I may miss, then that it would be otherwise.
Otherwise, the petitioner could have informed that there is no such notice information regarding the adding of new section, your lordship. So that section is there, your lordship, and
And
one.
you make your submissions,
Lordship.
but, not justified anyway. You make your submissions.
Lordship. Lordship, now what I got to know that the 35(3) notices has been served, your lordship. Here the case has been registered on 2/7/2025, your lordship.
Okay.
And it means, your lordship, it signifies itself, your lordship, that the petitioner itself cooperated the investigation, your lordship. Lordship, if your lordship kindly come to the FIR, that is page number 11, your lordship. The case starts with a misappropriation of 15 to 20 crores, your lordship, in the name of building some shopping malls, car dealership. That means some violation of agreement with the complainant or with some other clients, your lordship, with some other individuals, your lordship. Now, the case has been registered under section 316 and 3184 of the BNS, your lordship. The maximum imprisonment is 7 years. Earlier, I have submitted regarding 35(3), your lordship. Now, if your lordship kindly see the page number 11, your lordship, that the FIR, your lordship, there are 4 accused person, your lordship. It is Anirban Deori, Devarshi Borua, Bubul Deori, and Moon Devi. I am not the FIR name accused person, your lordship, here. If your lordship kindly see, if as per the submission of the prosecution, your lordship, 35(3) notice has been served to the petitioner. Yes, I also know that. I just, yesterday only I got to know that, and the notice, one notice, I have a copy of a notice. It was a second notice, your lordship, that 35(3) notice has been served to the petitioner. Now, if that notice has been served, your lordship, then 35(5), subsection 5 and 6 have to be complied with, your lordship. Because, your lordship, it means, your lordship, I have cooperated the investigation. I visited the IO, your lordship.
Despite that, he can be arrested, but reasons have to be given.
Reasons have to be there, your lordship, but that is not there. Yes, in the forwarding report, there have some, but that is not the satisfaction of this procedure, your lordship, section 35, your lordship, with due respect, you're subject to the correction, your lordship. Otherwise, your lordship, even before this, your lordship, one FIR of similar nature has been registered, your lordship, that I have earlier submitted before this honorable court, your lordship. That is the FIR.
But Kashyap Fukan, just a minute, sorry
Lordship.
for interruption. Kashyap Fukan, though not initially named in the FIR,
Yes, not.
allegedly one of the kingpin.
Yes, yes, one of the kingpin. Thereafter, my lord, on the basis of the statement of the other accused person and
Anyway,
materials.
please.
Lordship. Lordship, that FIR has been registered as 859, your lordship, registered as 3/9/2024, 61(2), 3162, 318. Similar kind of allegation, your lordship, I have earlier submitted, your lordship. Against Kashyap Fukan, Anirban Deori, Bishal Tamuli, Paul Bordole, Moyur Deka, along with total 7 accused persons are there in the earlier FIR, your lordship. Here, your lordship, the same allegation, your lordship. The Bullseye Company is not a company, a non-banking financial company named Bullseye operating in the Panegaon area. Company has been attracting gullible
That was
customers
filed subsequently,
earlier,
earlier.
your lordship. That might be there in the file, your lordship. Earlier, I have submitted, your lordship. If lordship permits, I'll submit it again, your lordship. Now, your lordship,
Yes, yes, I
in that case, your lordship, the CBI, your lordship, has filed final report, your lordship. The final report has been submitted by the CBI.
CID.
CID, your lordship, CID, your lordship. And in this regard, your lordship, the similar set of allegation has been registered subsequently, whether it is valid in the eye of law, your lordship. In the earlier, your lordship, my name is there in the FIR, your lordship. Subsequently, your lordship, after the initiation, after the registering of this FIR, instant FIR, your lordship, I have been served with a notice under section 35(3). I have cooperated the investigation officer. I have visited frequent times, your lordship, investigation officer, your lordship. Now, why arrest, your lordship? There must be a reason, your lordship. Why arrest? As I have
No, sometimes custodial interrogation, of course, in a civilized country, we'll never accept custodial violence, but custodial interrogation is sometimes necessary for confronting and all that.
Yes,
For
yes.
cross-checking and confronting.
Why
All these things are there.
Yes,
This
your
is-
lordship. What I just try to convince this honorable court, your lordship, the procedure which need to be complied before arrest is not there in my case, your lordship. Already this is 60 days offense, your lordship, investigation period, your lordship. 55 days already behind the bar, your lordship. Now, here, your lordship, Article 21, your lordship, because procedural aspects are not there complied with, has been validated, because I, each and every time on the call of a IO, your lordship, visited the premises of police station, cooperated with the investigation officer, your lordship. Even, your lordship, here in this case, your lordship, the rest of the accused person are outside, your lordship. But, your lordship, in spite of, your lordship, my cooperation, your lordship, in this case, your lordship, without complying the provision, your lordship, in this regard, I have been arrested, your lordship. Here also similar kind of allegation is there. If your lordship kindly compare, your lordship, the earlier FIR in this FIR, your lordship will found, your lordship, that the similar kind of allegations and set of allegations are there in the FIR, your lordship. In this FIR also, my name is not there. If your lordship kindly see, the specific allegation is against the Anirban Deori and the family of the Anirban Deori, your lordship, because they fled away.
No, investigation has revealed other things actually. His involvement has also been found as per investigation.
Yes, yes.
Yes.
This court is not saying, obviously.
Yes.
Anyway,
But the thing is that, your lordship, with due respect, your lordship, that here, if your lordship kindly see the FIR, your lordship, the wordings of the FIR, your lordship, it is the case because the Anirban Deori fled away, your lordship. This is the case for that reason only, your lordship. Their family members fled away. Their phone has been switched off, your lordship. For that reason, your lordship, without mentioning my name, your lordship, the FIR has been registered, your lordship. Otherwise, my involvement was there in the earlier FIR, your lordship. Whether the CBI already filed a clean sheet, your lordship. The final report has been submitted, your lordship. On the same file with facts of allegation, your lordship, whether the second FIR is permissible, your lordship. That is my submission, your lordship. Otherwise, the Satyendra Kumar until case is there, your lordship. They are in category D, your lordship. In Satyendra Kumar until case, that economic offense has been termed under Schedule D, your lordship. Category D, your lordship. Sorry for the, not schedule, your lordship. It is category D, your lordship. But here, it has been not mentioned by the Apex Code. If there is economic offense, the procedural aspect need not to be complied with, your lordship. That is my submission, your lordship.
That's to be
Yeah,
complied. Everywhere
lordship.
everywhere
And
it has to be complied.
Lordship, even I am relying on judgment. It was of economic offense of earlier finance minister, your lordship. That is P. Chidambaram, your lordship. I'm providing the judgment, your lordship. It has been fined by the Honorable Apex Court, your lordship.
Aspect of money laundering is can also can be involved right, in these matters. 50 crores allegedly is not a joke. I'll go through these things. So let me fix it for day after tomorrow. I'll see it properly.
Yes.
I'll keep this.
Regarding clean sheet by the CBI, my lord, in the.
Because he has raised different things.
Yes, in that case, my lord, already this victim.
Tomorrow also it may be.
So many victims, my lord, filed 193(9) BNS petition, my lord, before the CBI, challenging that FIR, my lord. In that FIR, my lord, what the CBI did.
Naraji petition.
Yes, my lord. My lord, during the investigation, my lord, they investigated and they took the statement of the persons, those who were not involved in this case, but did not take, granted them or even, my lord, take the statement of the persons, the victim, my lord, from those, my lord, these people, my lord, collected the money. My lord, sufficient material is there, my lord.
Actually, but actually, if it is the same offense, they have to amalgamate it also.
Yes, yes.
So that is also,
Yes,
otherwise the
yes.
procedure.
And my
is
lord,
very-
monies were collected from, my lord, collected through their personal bank account, my lord. There is sufficient documents is there, my lord.
Lot of grievance, of course, of the victims. That's why it is. Can you give me the name of the person you are representing?
Mine.
Because it has to be reflected.
One more thing I would like to drag the attention of your lordship, if your lordship permits.
Go ahead.
Lordship, at the time of production, your lordship, it is a duty of that jurisdictional magistrate, your lordship, to look after whether the 35 has been complied with, your lordship. Here, your lordship, that is not there, your lordship, by the magistrate at the time of production, your lordship. That is the bunch of order of this certified copy of the
Given date to some, एक minute date to some.
কালিয়ে থাকিব
even
আপনাকে দিম কালিয়ে থাকিব
even your lordship,
I will keep this.
lordship. There, one thing is there, 47 has been complied with, 48 has been complied with, 36 has been complied with, but not 35 has been mentioned in the order sheet, your lordship.
No, not mentioning is maybe secondary, but the compliance is more important.
Lordship,
If-
lordship.
If the compliance emerges, then it's okay. According to you, it has been complied, all the procedure.
Yes, my lord. Everywhere, my lord, in the
Should I keep this?
Lordship.
Everywhere in the case diary, your lordship, note of the IO, and thereafter, before his arrest in this case, his statement on 17/8, 13/8, 14/7.
I'll say, that's why I'm taking some time.
Yes.
Because others will also get delayed. I will take some time.
The bank statement, my lord. So which
And
my lord,
just a minute, will it be okay if I keep this part only?
yes,
This
yes.
I need not.
Yes, yes.
But it has to be, you have to keep it, because this part only I'm taking. Yeah. See,
My lord, these are the, my lord, statement, my lord. Through UPI, my lord, they collected them.
give me,
And these are the, my lord,
My lord, this is the file.
their agreement, my lord.
day after tomorrow. Day after tomorrow.
Otherwise, I have to submission on 47 and 48 to see if
fine.
your lordship is fixing it day after tomorrow, your
But
lordship.
55 days, right? So
55 days, your lordship.
I would like to give it tomorrow, but that meeting also today, some time
Day
constraint.
after tomorrow would be convenient, no? Day after.
And there's a meeting also today, so we are. Day after tomorrow.
On Friday,
Day after
Day after
tomorrow, lordship.
Day after
Lordship,
tomorrow.
lordship.
I'll try to complete today only. Anything else you want to submit?
Yeah, 47, 48 is also there, Lordship will direct attention on that day, your
I'll
Lordship.
see that. too.
Lordship,
I'll see that also.
Lordship.
Otherwise, prima facie, I was finding it difficult because this kind of offenses, actually 60 days is insufficient, but that's the law. Actually. In that sense, law has not kept,
Here, your Lordship.
kept pace.
Yes, your Lordship.
Law
With
has
due-
not kept pace.
With due respect, your Lordship, even in the earlier occasions also, the similar type of cases, even more severe cases, your Lordship, of 2000s rupees trading, online trading has been before this honorable court, your Lordship. But procedure doesn't permit them to, your Lordship.
The
for-
procedural requirements and constitutional requirements apply, they apply to everything.
Lordship, Lordship.
17.
May I, your Lordship, your Lordship is fixing it for
Sorry,
hearing.
not 17, 16. We have to-
Lordship is fixing it for hearing or your
Order,
Lordship?
order.
Oh, then
Deliberate.
I have to keep attention to 47 and 48 also, your Lordship.
Okay.
Lordship.
When everything.
Submitted certified copy, your Lordship. Your Lordship, kindly see 47 and 48, your Lordship. Yes, your Lordship.
From the act,
Yeah, Xerox copy. Yeah, your Lordship. The same set of allegation along with Anirban Deori has been copied paste, your Lordship, in 47 and 48, your Lordship. Here I am not the FIR name accused, your Lordship. 47 and 48 reveals I am the FIR name accused, your Lordship. If your Lordship kindly see the third number paragraph, the ground of arrest, your Lordship.
Third.
Ground of arrest, your Lordship.
Hmm.
The trading entitled, namely Bullseye, as cited in the FIR, was found to be registered in the names of the accused person, Anirban Devi and Kashyap Fukan. Though this company deceitfully induced members of the public, including the complainant, by making false promise of exorbitant returns. In reality, the accused person, under the guise of operating Bullseye Foundation, fraudulently amassed approximately 44 crores from numerous individuals. The promises made were never honored, thereby establishing a clear act of cheating. Now, this is not the offense allegation, your Lordship, set in the FIR, in the instant FIR. This is the allegation. Maybe they dragged from the earlier FIR, maybe, your Lordship. I don't know, your Lordship. But these things doesn't reveal in the instant FIR, your Lordship. So that also not complied with, your Lordship. 47 and 48, your Lordship.
anyway. I'll keep it,
Lordship.
yeah, 16, huh?
Lordship.
16 morning only I can deliver. Complete. I will complete it today only. Also. Otherwise, this will take time. Yes, this will get delayed. Okay?
Five.
May I please, Lordship. My Lord, may kindly see FIR page 9. 25, my Lord, as per my instructions, search sheet submitted, my Lord, in this case. Against
You're saying FIR at page?
page 9. In this case, my Lord, 3 persons have been made accused person. Accused number 1, Gopal Sutradhar. He has been arrested, he is in custody. 2 is his father and 3 is his uncle. As if the father,
Sutradhar and Santosh Sutradhar.
so as if the father, uncle and the nephew jointly has committed a crime against 13 years guard. So my Lord, we are for 2 and 3. 1 is already on, he has been arrested.
He's in custody.
He is in custody. So allegation against 2 and 3 is in the FIR is like that they have asked the complainant to withdraw the case. This is the only allegation.
Okay.
And they have also appeared before the IO and given their statements.
They were granted interim.
Yes.
They were granted. Fine, but the only thing that, yeah.
Already as per my instruction, my lord, search sheet submitted.
Search sheet submitted, but what about this notice thing? You have to,
Notice, my lord, I
In
will
that-
have to get the
huh?
instruction.
Huh?
again. Notice, my lord. you
notice
will-
was sent. In that case, we'll have to extend the interim
Yes,
and wait for that.
yes, ma'am.
But the other case was different, the default bail, that I accepted this contention. That in default bail, since we are not looking into merits, perhaps we can. I don't know, rightly or wrongly. But in this case, if it's largely on the ground of completion of investigation,
Yes.
if we
Already
consider,
petitioner
make it
claims we
absolute.
already,
Don't you think so, sir? This process will not be complete if we do not notice the informant.
That is the lacuna of the investigation.
No, you have taken steps, but it has not been served, not yet been served. Any office note?
No, ma'am.
Steps to taken, steps is been taken. You take instructions.
Yes, ma'am, I
Huh?
will get the
You take instructions, full stop. Peruse the last upper thaibo, I said Mahmood and Peruse the last previous order dated 5/9/25. Full stop. The prosecution submits today that in the meantime, charge sheet has been submitted. Full stop. The
My learned friend may bring whether such is submitted against whom.
that also is there.
Yes, that is necessary because
May not
father
have
and,
been, may not have been.
yes,
May not-
father and son and uncle.
If that is the only allegation against them. Right. The petitioners were granted interim PRS bail by the order dated 19/6/2025. Full stop. The learned prosecution shall take instructions regarding the accused against which charge sheet has been filed, and secondly, regarding service of notice upon the respondent. The interim bail stands extended till the next date of listing. That's the only option. Otherwise, I would have disposed it. Actually. So how many days after?
My lord. On 10/11,
So long.
4/11,
Okay.
already interim is there, ma'am.
No, into 4/11.
How like?
Then a scan copy of already search sheet, not
Can copy of charge.
search sheet.
Since we are taking time.
Yes.
Instead, you're taking instruction or,
Yes, I will get the instruction.
okay, take the instruction.
Yes.
Okay. You'll get the instruction. 26.
May I please, your lordship? The pre-arrest bail application, okay, in fact is that regarding the allegation is made that they had a love affair to major person. Love affair, and later on she realized that she came to know that the petitioner is a married person. And that is why lordship and some physical were there between them. This is the case, lordship. I have got interim and I appear before the IO and rest lordship case that you will see. The version of this short, no?
The disturbing part is that viral, that is the spectrum. Otherwise,
The victim statement recorded lordship, she is fully implicated and stating that relations was made on false promise to marry.
then that aspect is suppose we overlook
But-
also little bit, since he's a major, little bit, but the worrying part
Yes,
is that.
viral the photographs,
Any IT Act section is given?
yes,
No.
66,
66
Yeah,
D is
66, yeah.
66 and 76.
your team, any of you, they can instruct. Because
Anyway, my lord,
the
since I am
criminal
only the owner of the land, my lord.
owner of the land where this was going on.
I have given the land on rent for opening a water bottling plant, my lord, to the main accused.
But he ran a liquor.
They didn't recommend, in fact, land was situated far away from my residence because I was not able to know whether it was used for water bottling plant, my lord. Police station.
What to do, Prasanna?
So Lordship, a cost list of, in the cost list, Lordship, there should be the excise party name should be reflected, Lordship. CD will abide by them, Lordship. Otherwise, it is difficult for us to bring the case diary, Lordship. What is the status of the case? Because the excise is an excise case.
Yes, yes.
Then Novas is the same. Novas is Kusami.
Perused previous order dated, previous one, the earlier order dated 27/6/2025. Full stop. The petitioner is on interim PRS bail. Case diary not yet received despite elapse of several dates. The case has been investigated by the excise department of the state. Stop. The name of the learned counsel representing this prosecution by the excise department. But the state excise department may be reflected in the cause list. Full stop. Further issue reminder for the case diary. Actually, this reminder won't serve purpose unless it reaches. You can help him, guide him with
Copy
that.
of the petition of this to deliver to the excise.
Interim. Because interim it will be extended, but matter also, this should not linger. This also, bail petitions will also not linger, we should dispose it. Interim bail stands extended till the next date of listing. Granted by order granted by order dated 27/6/25. Stands extended till the next date of listing.
May I prefer short date, my lord? I will have copied the setting of excise point.
Let it be on Tuesday.
27 or 27? He's on interim.
27?
Yes, my.
27/10.
Be happy to solution. Well, the Mary to man has lost this FIR, Lordship. Page 7 is the FIR.
Who has lost?
Mary to man.
We have not received the case diary, Lordship.
Allegation under section 376 and 66E, 67A IT Act. As per allegation, Lordship, the incident was taken place in 2 years back.
This earlier rejection order? or-
Yes, Lordship, I have annexed there.
Yes.
Yes,
Then I can take up.
14.
I'll have to take up.
Only part your Lordship will, you can see whether her allegation, main allegation is that some fact has been Lordship made viral. That part, whether he has done or not, that is to be seen.
Diary has come.
Not received, Lordship.
So not received.
So earlier rejection order,
Just-
number 7, Lordship, is clearly reflected case diary. Number 7, Lordship. Like from the case diary, it is seen that the statement of the independent witness, which have already been recorded by the concerned investigation officer of State Bongaigaon PS case, number such and such, indicated that it is the petitioner who has circulated such videos of obscene scenes of the victim to the others and he is evading arrest. So there is a material, so case diary, we have to refer to case diary.
Case diary will be necessary.
Only at 2 occasions, Lordship,
No, more case diary
Yes.
will be necessary, no, because
short
considering the
date may
nature
be
of the
given.
allegations.
A short date may be given.
Case diary is not yet received. The learned additional PP brought my attention to the earlier rejection order dated 12/6/2025.
Yeah.
It has been fairly annexed with the bail petition. The issue reminder for the case diary. List the matter on
28/10.
20.
28/28. 28.
28.
20 বন্ধ আছে।
This time on. We live in a time of electronic age, and also social media age. Law will be there to protect you, but we also have to be careful ourselves. Men, women, sometimes some cases more especially women. We should not,
This is there,
we should be careful.
AI is there, Lordship.
In my, I did not know this thing, that I did not know that, I came to know from one of my friend that in many Western countries, you are not allowed to take photographs of children. So which is normal in our country, because they have bitter experience.
Lordship.
Made clear, Your Lordship. Yeah, FIR, Your Lordship will find page 10.
Page 10.
Page 10. Lodged on 30/8/2025.
Diary?
There is report.
Here, before going to that case diary, Lordship, may I kindly see that date of incident, that is 13/8/25. Page 10, Lordship. Date of incident is 13/8/25. And FIR was lodged on 30/8/2025. And my instruction is that, Lordship, that victim girl was having some one-sided love affair with the petitioner, who is a teacher of the said school. He refused. And that incident, Lordship, that school, some school boys, Lordship, that they got to know, and they spread a rumor that they are having an affair. But although there was no affair at all, Lordship. So therefore, thereafter, Headmaster, Lordship, held a bichar, and wherein the girl also said that there is no affair between them, Lordship, at all. And as per my instruction, probably her 164 is also recorded, and she has stated the truth, Lordship. So that part, Lordship, may I kindly see. And this present affair was lost due to pressure of some other person.
You call for the.
My lord, I may be protected, my lord, interim, I will cooperate with the investigating agency, my lord. To test out the vehicle.
Yeah, I was thinking of that. You record your statement.
My lord, my lord.
That will help the investigation. Case diary is not yet received. Mr. Sigdar Learned Counsel, taking the court through the FIR, points out that the alleged incident is of 25/7/24, and the FIR came to be lodged on 29/8/2024. From the FIR, it also indicates that perhaps the accused and the informant are known to each other, because he was stated to be present at the time of his buying the vehicle in question. Anyway, it may assist the investigation to allow the accused to get his statement recorded. Therefore, issue reminder for the case diary of Panchgram PS case number 80/24. In the meantime, in the event of his arrest in connection with this case, to go 20,000 with one security, subject to the condition that he shall cooperate with the investigation and shall appear before the IO, making himself available for examination. This is the matter. Fix it.
Deep level, long 611, my lord. 611. Deep level.
611.
Lordship, the argument counsel is out of station, and let's say the case there is there, if it may be retained and maybe fixed on day after tomorrow.
Interim is not there.
Earlier.
Diary has been received.
Received, earlier rejected by the version.
Leaves the matter. The arguing, the leading counsel stated to be out of station. And the learned, your good name, please?
DK Agarwala.
Yeah, 6 and adjournment. Which is allowed. Leaves the matter on, when should I, day after tomorrow? 16/10.
The CD may be retained.
Has to be retained. This diary be retained.
Much obliged.
This matter is, my lord, POXO is there.
Hotel, no?
Yes.
In
Uh,
Mordor.
but in fact, now I find that what your lordship, the one
He recovered from one person, was arrested by the police,
10 grams. no?
10 grams with plastic container. And after investigation, it has been found that 8.13 grams has been actual weight of the.
Without the packet.
Yes. Now, question is, my lord, I am not in any way involved. Those articles has been recovered from one Sofiqul Islam. And after interrogation, he disclosed that I am also doing such business
involved.
This is the only allegations. So
Thank
now
you.
the police asking me, my lord, I application will go.
Kindly cross-check that aspect. As usual.
Yes, yes, initially police arrested my lord Sofiqul Islam. And,
With
uh,
articles.
And on the basis of the statement, my lord Sofiqul Islam stated that, my lord, he is the person, my lord, who is directly involved in, my lord, running this business, my lord. And on the basis of his statement, my lord, because investigation at the initial stage, so, my lord, thereafter other witnesses also stated that he is involved in, so now police is.
Other witnesses have stated.
Yes, yes. my lord.
That
Other-
aspect you kindly see. In that case, it may not be justified.
Yes, my lord, others, we stated, witnesses statement is also there.
Those person may be jealous with us, my lord.
Have to go a little past.
Not only statement of the, my lord Sofiqul Islam, but others.
Sofiqul Islam is the
Sofiqul.
main accused.
Yes, main accused.
He is the arrested.
Yes. There are-
Huh?
There are other witnesses also there.
বুঝল আমার কাছে বুঝল ছবিগুল আমি ছবিজুল I am Sobizul. I am Sobizul, not Sobigul.
Safizul Haq.
I am Sobizul Haq. Someone may say, my lord, something without any evidence. How can I maybe book, my lord?
No, only co-accused, that's true. That is true because why? What is the, I mean, we know, no? What is the philosophy behind that? Because if I'm an accused, my credibility is low.
Yes.
I may always lie to escape. So that is why this is very right, actually. But the thing is that that's why we have to see other materials. Though only co-accused statement automatically may not, if I have not understood wrongly, Tufan Singh has only talked about trial.
Yes,
You know,
only
but
talk-
that someday that will also emerge, that what will be the stand? Will it be automatically entitled to bail if this only material is co-accused statement or not necessarily? Depends. It's an open question, I think, in my opinion. But, we have to always see for the purpose of this, that whether there is any corroboration of the co-accused statement.
Nothing, my lord.
No, here, this one witness I've seen.
Yes, the one. Investigation is going
But
on.
thing is this, my lord, article may be not found in my positions. This is the main thing.
Because this.
Anyone,
is very,
many person may say something, man.
This is, my lord, very initial stage of the investigation. So, my lord.
Under any
otherwise-
condition, my lord, I will cooperate with you, any condition. Slightly above from the below quantity.
Third J. Amit consultant, P. Botakur. The petitioner is seeking anticipatory bail in connection with Goripur PS case number 377 of 25 under section 21B29 NDPS Act 1984. Good stuff. The case arose out of FIR dated 5/9/25. upon source information, operation was carried out and and suspected 10 grams of 10 grams of suspected heroin was found from one Sofiqul Islam, son of Nur Muhammad. Full stop. It appears that the present petitioner, Safizul Haq, son of Sirajul Haq, was arrested.
No, I am not arrested.
Sorry, he was his name emerged, the name of the present, so and so, son of so and so, emerged from the statement of the arrested accused. The case diary as called for has been received. The learned additional PP submits apart from the statement of co-accused, there is implication emerging against the present petitioner from the statements of other witnesses also. I perused the statements of two witnesses in which, two witnesses, comma, both of whom have stated about the involvement of the just a minute, there may be a mix-up. Though they have the same name, no?
Yes, Sofiqul, I am the Sofizul.
You have found statements against this person.
Yes, well, I will check.
Can you check it again, because we should not go wrong. That's why I mentioned the father.
After some time.
I am Sofizul.
Just a minute, I think
Against us.
witness, no,
The statement of other witnesses is there.
no. Hello. Let me just give it. Kindly cross check it once.
Yes.
After some time. Yeah.
Yes, madam, I have flag mark two witnesses, my lord, named Sofizul, my lord. He is the seller, my lord, present petitioner.
Then in that case, it may not be justified. Otherwise,
Yellow flag mark, my lord, two witness one and two. Sofiqul and Sofizul. He is the present petitioner, is the seller, my lord.
That's okay, last sentence. Have stated about involvement of the present petitioner as well in right? It is present petitioner in peddling of drugs. Full stop. In the given facts and circumstances, as the investigation is not yet completed, I do not deem it wise to grant anticipatory bail, and the same stands rejected. Return back the case.
Lordship, the senior counsel engaged in this case has some personal difficulties today. Lordship, may kindly take up this matter on 17th, Lordship, Friday. CD is here. I am told that CD is available. CD may be retained. 17th.
Is there is receipt?
Yes.
Yes.
However, an adjournment is prayed for on behalf of learned senior counsel to some personal difficulty. Let's do prayer aloud. List on 1710. CD be retained.
Obliged.
Oh, bail, he hold on.
May I please Lordship? Lordship, conducted counsel Mr. K.S. Kondakar is not well.
He's not well.
Yes. That the matter is adjourned.
Another day, another
Another
day.
day. After Diwali, Lordship.
Just one. Okay. Your
I'm for the informant, your lordship.
informed. What is the matter actually? Just a minute. Just have a look.
I filed objection in this case, your lordship.
Diary has been received?
Yes, yes.
You have, this IA is for,
For objection, objection it is. For cancellation of bail.
for cancel,
Granted,
for
yes.
cancellation of bail. Disposed of bail application.
Yes.
This will, not this will, pending it.
Just a minute. Oh, so you're objecting to the prayer for bail. Objection can be filed in the same also. A separate IA is necessary for objection, filing bail objection, right? Private informant. May not be necessary. It can be in the main case also. Anyway, your file, it's okay. It will go to, basically it's a bail petition, basically. No? Day after tomorrow?
No, Lordship, after Diwali.
After Diwali?
Diwali.
After Diwali. Interim order is not there. No?
No, still maybe served a copy of the petition, copy of the petition.
Objection?
Yes, objection and the petition.
Okay. In the meantime, kindly give a copy. Your good name, I'll record your name. Your name?
Rumana Parvin.
R. Parvin. And counsel. Submits that the leading counsel has some difficulties and seeks a date after the date in next week. Prayer is allowed. And counsel appears on behalf of respondent number 2, informant, and has filed an interlocutory application bringing on record a bail objection. Full stop. The petitioner shall serve a copy of the bail petition to the prosecution. You have and you've got the objection.
Yes, my
Objection.
objection also.
You have also got objection. I said it. You've got
Yes.
objection.
Lordship, CD may be written.
Oh yeah, case diary has been received and shall be written. List the matter on. You suggest it.
On my lord, after the PTO.
Also her.
27.
November, October.
Yes, my lord, on 28, my lord, 27.
27, 20, 28.
28.
Okay.
This is the October.
May it please, your lordship. Lordship, in this case, my lord, I am saying. 48? 40 or 40?
48, I'm so sorry.
My lord, I am challenging the proceeding, my lord. Matter pertains to, my lord, here petitioners are their husband and wife.
had committed rape upon these two victims and had beaten up the two boys. Now, the defense's contention was